trusts by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome everybody this Tuesday, March 23rd, 2000 edition of Money Banking and Trust by Moving Titles in Commerce. I'm your host, Christian Walters, and this is the Tuesday night call for Q&A, so yeah, we'll open it up right up for question and answers. So press star 5 if you're not speaking. To unmute, press star 5 again. Anybody have a question, press star 5 and state your name, where you're from.
Okay, can you hear me?
Yes, I can.
Okay, this is Floyd. I got a question about the indenture.
Sure.
I was reading today. I was trying to get a little sense into this, and it says in blacks, a formal written instrument made by two or more parties with different interests. When we're doing an indenture, then are we looking to merge, or are we looking to set up an agreement with the private and the public?
Well, it's not so much as an agreement. It's really a relationship between three parties, the grantor, trustee, and the beneficiary in relation to a specific trust res for the benefit of that third party, the beneficiary. So it's really a relationship, not so much an agreement. All one really has to be is be the trustee, and he's going to accept the duties.
Okay.
So the indenture is really kind of like the intent and purpose of the grantor is put down in writing, or it could be oral.
Yeah. Well, I was thinking that for the indenture, with the birth certificate specifically, is what we're trying to do is, I think what we're going to be trying to do is give instructions to the public to bring the private in. Is that what we're going to do?
Yeah, but it's kind of like a colorable thing that you really want to tell the public, because that's really your substantive rights held in the private.
Right. I understand that it's colorable, but when we form an indenture with that in mind, that would be the direction that we would be looking to bring in. I don't know if you'd call it evidence or what you would call it, but anyway, to build your premise or instructions.
What's your indenture for? What's your purpose on the indenture?
The purpose on the indenture would be to let the public know that you're a private man.
Well, yeah, you could put that in there, but I don't really know if that's necessary or not. So I'm trying to get where your focus is. Is it on the public side, or is it on the private side?
Well, it's focusing on the public side. Well, no, it's noticing the public side to get into chambers or wherever it is that you have to get into, because you're gonna want to keep that indenture private, aren't you?
Okay, you're talking about getting the whole master account, the whole thing, right?
Right.
Strawman. Okay. It's like the only thing I'm going to be writing an indenture or forming a trust on is going to be when I close down the master strawman trust account, and whatever's left from after paying the debts is going to spill over, or the remainder is going to be now transferred into this new trust, and I would need an indenture for that. I'm really not making declarations that I'm not associated with anything. It's just, I'm forming this new trust just to put the funds in the private.
Okay, yeah.
And then simultaneously create an LLC on the public side, and really the public's not going to really know of anything I'm going to be doing. I'm going to operate on a face mask premise of a second straw man, being this LLC. And I'm really not going to be telling the general public what my business is, because if I did, I'd be commingling my own trust.
Well, that's why I was saying that you would be keeping that in the private.
Right.
But how are you going to get a judge? I mean, how are you going to get before a judge in order to activate the indenture or the LLC or whatever it is?
Well, how would you normally form a trust or an LLC?
Oh, okay.
I don't do it with a judge.
Pardon?
I don't do it with a judge.
Okay, so then the other, I was thinking the other way that you would have to do it would be by tacit agreement.
Well, no, I'm tacit agreement with who? A judge?
Well, no, with whoever it is that you're noticing. Because you're going to have to notice somebody, aren't you?
Yeah, I'm going to have to notice the public of certain things I'm doing. Yeah, what is a certain thing that I'm doing?
Well, the certain thing that you're doing is you're doing away with the public side of the trust, aren't you?
Right. Now, how am I doing that? What am I actually doing according to trust?
Well, what you're doing is you're now taking control of the trust.
Yeah, but we're going to merge the titles and we're going to terminate the trust.
Right, exactly. But in order to do that, you have to get.
What are we doing? We're terminating the trust.
Yeah, we're terminating exactly by merging the public and the private side.
Right. Now that doesn't involve an indenture.
Oh,
it involves records to prove that the titles and that trust has now been terminated. So I'm going to be giving orders to pay the debts, past, present, and future debts, all off. I'm going to be giving orders to discharge on the public side and orders to set off on the private side. Bring the accounts to zero, in other words, close and settle the account. And then I'm going to order the remainder into a new trust that I'm going to order formed, and it's going to spill over, or the remainder is going to be put into that new trust.
Is that where the indenture comes in?
Then that's where the indenture comes in.
Oh, okay. Well,
then I'm going to form that LLC simultaneously on the public side, so that I got a face mask I can interface and do commerce, so to speak, although I'm not generating a profit, and I'm not being effectively connected with the United States business or trade. So I can
all you're doing is using
through that LLC.
Yeah, your LLC, or the LLC. Let's see, what are you using for trust res then?
Well, I'm going to generate interest off of the privately held assets in the new trust on the private side. I'm going to generate interest on the public side, and that interest is going to be deposited in that LLC. That's on the public side.
Well, what you're accepting, turning though that was there is isn't that the public side? I'm not quite sure. I'm not quite clear on what you're returning for as trust res.
I don't have a trust on the public side anymore.
Oh, okay.
I just have an interface that is an LLC, a corporation, so to speak, that I'm using that to interface in and do my purchases, to purchase my... Press star 5 if you're not speaking.
There's a lot of static on the line tonight.
Yeah, so where were we? We were talking about that LLC. That's the
LLC.
That's just an interface in on the public side. Because I've terminated the straw man. He doesn't exist anymore.
Okay. Okay. So that's a little different than what I was looking at it then.
Actually, it forms like a circle. If you split the circle in half, that's public and private, and I'm just like following the outside circumference, and I'm coming around, and I'm making a circuit.
Well, that's why I was thinking that what you're doing is you were operating. I know you're going to operate the private side, but you have to keep the private side private. So that's why you had to notice. You had to notice the public somehow that you're doing that, so that you would be in control of both sides at the same time.
Yeah, because I'm going to terminate the straw man and the birth certificate, those two entities on the public side, which are the portals crossing over into the private, really. I'm going to terminate them. I'm going to eliminate them.
Okay, and then you're going to operate. The LLC, or you're going to have a trust. Let's see, would be
form a trust on the private side. I'm going to form an LLC on the public side.
Right. Okay, and then you're going to have a administrator operating the public side for you, right?
No, I'll probably operate the public side myself, but I'll be operating it through this LLC.
Oh,
It's the new face mask. It's the new straw man for me.
all right. Okay.
So all we have to learn how to operate a trust or administer a trust.
Yeah. Okay. Well, I wanted to. I needed to bring that up at least to clear it up in my own mind exactly what we were shooting for here.
Right. Mm-hmm. Does that make it a little clearer?
Yeah, that'll make it clear. I still have to think about it a little bit more because the operation, the actual administration of the operation is something that I'm still not quite clear on, but it'll drop into place.
Okay, we're going to have a little background noise. I'm going to press *5. Then you'll have to press *5 to unmute again.
All callers are muted and they can unmute themselves.
Okay, somebody else have a question? Or are you done now, Floyd?
Okay, can you hear me?
Yes, go ahead.
Okay, it took *6 to unmute. Okay, yeah, I'm done. I just want to clear that up in my own mind. Thank you, Christian.
Okay. Yes.
Jacob, how are you doing?
Jacob, how are you?
Okay. About the conversation you guys had, is your reason for terminating that trust, number one, so it doesn't have a stronghold on you, and number two, because you believe that there's abundance funds in there, and you want to acquire the abundance of funds over and above of what supposedly believe you owe?
No, it's the principle that upon merging, that is a payment, and upon making a payment or merging the titles, that also simultaneously terminates the trust. It's a necessity. It has to happen.
And why do we care about it?
Well, when that terminates that strawman trust account, now anything else that's associated with it, automatically, when you pull the root out, all the leaves of the trees die.
Okay, so whatever it's comporting with that's unknown or known,
yes,
is what you're trying to
totally
get rid of?
terminated. Everything is terminated with it.
Right.
It can't have any ties with it anymore. It ceases to exist. It's terminated.
Now, you're going to start, you want to start an LLC and a new trust in the private and LLC in public.
Yeah, I need to interface back in somehow because I've lost my face mask. Because actually, that strawman account was my face mask interfacing into commerce, into the public side.
Right.
So I got to have something to take.
But also, you keep mentioning that there's going to be a spillover of funds.
Right. Because it only takes 1 penny worth of actual money to pay all fiction debt.
And how do we know there's money in there to worry about?
Well, all that money's being held in trust since 1933.
Is it our 350 millionth of a share?
Well, it's grown to where I understand at least $3.5 billion per person who has a birth certificate. At least that.
So the total fund is 300 million or 350 million times 3.5 billion. That's what your bid.
Actuality, it might be as high as say 350 billion. Who knows how much is in there? I don't really care.
Okay, that's the reason I was just wondering. I see the logic, for having the new LLC in the public and then a private trust a trust in the private. That makes a lot of sense to operate that way. But why do we have?
I've got to close out the debt associated with the old strawman. I've got to close out all the past debt, the war debt, any other kind of debt, present debt, and all.
Why do we care about them? Why don't we just create a new identity?
Because then your trust is still open and you still owe the debt, and that's what's keeping everything from happening, because it's being held in trust, separated. It's not commingled anymore. Republic of America is in trust. You can't access it. It's being held in trust.
So which are the two titles that are to be merged?
Birth certificate and the Social Security account.
Okay, and
along with the live birth certificate.
The live birth certificate. And what position is the live birth certificate in? The grantor?
Live birth certificate is the private title to the real man.
The private title to the real man.
Birth certificate is the title to the straw man, the counterpart.
I got lost. It didn't. The sound went away.
The private is the live birth. That's the title to the private. The title to the public is the birth certificate. The live birth, private, the birth certificate, the public. Merge those two titles, and that strawman entity terminates.
Okay. Okay. Now there's the live birth in the private and the certificate in the public.
Yeah. Now what happened is that when the birth certificate at 18, you didn't take over the account, so they formed a new account, the Social Security account, which became a spillover one from the foreign situs of the birth certificate, and now the funds are being held in Social Security.
Oh.
So I'm going to terminate the Social Security and live birth, or the Social Security certificate of birth, birth certificate, merge those two with the live birth certificate and terminate Social Security, birth certificate, merge it with the other one, and that's going to terminate the whole account, both those accounts. And then the remainder, that's paying the debt, because I'm merging the title. Merging the title is payment. So I'm going to make a payment for the past, present, future debts on that strawman account. And the remainder then is going to spill over into this new trust we're going to form, held in the private.
And you don't have to be accurate in knowing what that amount is?
Doesn't matter to me one bit.
How do you ever know you got treated justly or fairly then?
Well, what I suspect happens is that they have taken and absconded with the funds and sold it to China or Germany or someplace. And they're going to give me some colorable tickets, certificates of gold or certificates of whatever they're going to give me, and they're going to try to sell me a bill of goods that is real. That is not real. Those are fiction titles again. They're trying to trick me. But I'm not going to fall into that. And I'm not going to, I'm going to forgive my brother, and I'm going to forgive them of the did by commingling the trust themselves and breaching the trust by commingling it. Because they can't give me the gold back. They've sold the gold. But they're trying to give me these colorable IOUs that they got for it, and I'm not taking them. So I'm going to play this game this way. I'm going to form this new trust, and you take all those assets and you put them in that new trust, because I'm not going to take those assets and commingle it myself, because that's the bait. They're trying to get me to commingle it. No, I'm going to put it back in on the private side and maintain it on the private side. It's never left. Because that
means the colorable IOUs are going to go into the new private trust?
Yes, the whatever they say that is supposed to be there isn't there, I believe. But I'm going to forgive them of that debt. And I'm going to tell them, form a new trust, and put the remainder from that, or what should be there, put it in there.
In the private?
Yes. Now you owe me an obligation, and that obligation, you're going to fulfill that obligation by generating me interest on the public side, and you're going to put that interest in my new LLC. And that interest is going to function as credit or debt, whatever you want to look at it. It's going to be like a credit card or a check, whatever you're going to see, and it will be looking like everything else, and nobody's going to know the difference. Questions?
Christian.
Yeah.
You appear to understand for a long period of time, back 1,000 years ago. Now, there are stories that we know about where people were given a new name. You familiar with what I'm talking about?
Yeah, I believe so.
One of the most famous ones is Jacob.
Mm-hmm.
He was given a new name, Israel.
Right.
And so, what has that type of new identity got in similarity to ridding oneself of the straw man? Because when you do that, you're no longer being able to be identified as that fictitious entity anymore. Correct?
Correct. He's gone. Doesn't exist anymore.
Well, there is a new identity born, so to speak.
By LLC.
An LLC.
Now,
what happened to the
new LLC is not just like a new, say, trust with the exact same corporate name, all caps name as mine, similar, but with a new number, say a new Social Security number. And that new Social Security number is a new number 98 number. And that 98 represents a non-resident alien that is not effectively connected with a business or trade, like off the W-8 bin.
Okay. And it's not possible just to start off with the new LLC and a trust and just have a new name. It's not enough to do just that. You have to go through and deal with this old scenario to terminate it.
Yeah, I've taken care of all the old scenario by terminating it, yeah. But
and if you didn't do that, what would happen? What if you put the new into effect and you didn't take care of the old? What would happen? You'd still be liable for being under discretionary trust?
Yes, because the straw man still exists, and you're still liable for its dead.
Okay. Well, thanks a lot. I want to think about all that. There's a lot to think about, Christian.
Yeah, well, that 1/27/2010, there for about the first hour, I went in pretty good description.
Which one?
1/27/2010.
Okay. I'll visit that. Thank you. One other question.
Yeah.
Hey, this is Terry. I don't mean to interrupt here, but the actual date is 1/26.
What is it again? 1/26?
Yes.
Okay, 1/26 then. My mistake. Sorry.
That's the one I sent you a transcription of as well.
Yeah, that was a Tuesday, wasn't it?
Right.
Yeah.
Okay.
The other question I had was, the other night you did a fantastic job of explaining going to closing with me.
Right.
Then I was listening to, I guess it was the 223 or 230 tape, and there was a gentleman on there that got into a long understanding of the grant deed. And when we talked about the mortgage deed at closing in the non-judicial state, we had the mortgage deed of trust going to the county.
Mm-hmm.
We had promissory notes going to the beneficiary or the bank.
Right.
But what role is the grant deed?
Well, that was the receipt you got back thanking you for your deposit put under trust from the county.
Ah, that I did. Okay, that was the receipt thanking me for giving me my business.
Yeah, your trust res.
You mean not the trust res?
You
the trust.
You recorded your documents of the sale and transaction, and they gave you back what? A warranty deed, a deed of title, a deed of trust, whatever you call it in your state.
Okay, a deed of grant deed they call it.
What you got back from the county was actually a thank you receipt of your special deposit that you made with them, but you didn't know that because you didn't understand it to be a trust.
Okay.
Just like
certificate,
just like the birth certificate is a thank you receipt, mother's special deposit into the state, forming a trust. So that birth certificate represents that held in a special deposit, really. So does that warranty deed.
Okay.
They don't do anything different. The MO of Satan is the same from the beginning at Adam and Eve through Christ when he did the same thing on the mount, and it's the same MO that he uses against you, trying to trick you into giving you something that you already own and have. Jesus was tempted on the mount, and he said there, I'll give you everything that you see out here if you just worship me. But Jesus already owned it all anyway. That's exactly what the devil does in operation of debtor-creditor relationship on commerce today. Trying to get you to take a benefit that you already own.
Okay, so this would be the final time I ever ask you this, hopefully. I'm expecting. Let me put it back. You hear that?
Yeah, I'm gonna unmute yourself.
All callers are muted.
Unmute yourself and come on back in. Star 6, I believe. Can you unmute yourself?
All callers are unmuted. All callers are muted and they can unmute themselves.
There we go. Now try it.
Is there feedback?
Nope, doesn't sound like it.
Well, whatever you did to work, but it blocks it. What you did, it blocked, and then it didn't allow my line to unmute and did something else.
You're right. I had to do it again.
And then yeah.
So
anyway, so at closing, I've signed a deed of trust, which is recorded with the county recorder, and I get back a grant deed as my receipt.
yeah, that was the thank you receipt.
My thank you receipt.
Yeah.
Promissory note goes over to the so-called beneficiary, the bank.
Bank, right.
He shipped that off to his buddies.
Yeah, they securitize it and they're taking care of it for you.
Right. Now, whatever happens to the credit application?
It's probably still held in the record someplace. Now, you could treat that as another separate trust or incorporate it into this trust, but, it's up to you what you want to do with it. Because obviously that
it's got to be tied to the straw man thing, right?
Everything is, yeah, because it has to portal through the straw man account into the private to have access to the thing, and that's all they want is your signature to do that.
So have you ever known anybody to get their credit application back?
Well, I don't think anybody has ever treated it as a trust deposit to begin with, to really ask it back and then take it into a court, into an in-chambers hearing, and let equity force them into bringing it back.
Yeah. It's got to be vital because it's the first signature. It's the foundation.
Right, but nobody's coming after this with trust, and that's the key, really, because that's what they've been coming at you all along under disguise of admiralty. Because admiralty shifts into equity, but they didn't tell you equity is trust, and then it shifts back out into admiralty.
Okay.
So the enforcement was in equity. It was in trust. And that's where they got you, as being the trustee, and you went to prison being a trustee that was in breach of trust.
Now, somebody, let's say any of our children out there that are brought into the world today, how do we look at a newborn?
Well, a newborn is in a private, but trouble is the way the world is set up now, everything has been split, and the split is there's a counterpart, and the counterpart is a straw man entity. It's fiction.
So what if somebody protected their child against that and they don't have straw man?
I'm afraid that person has really put that child into such a barren wilderness that they won't be able to survive.
Yeah.
Because everything that you and I are accustomed to using is gotten from the public side by a colorable title.
Mm-hmm.
Christian, can you hear me, Christian?
Yes.
Oh, good. I wasn't sure if I was unmuted or not. I'm trying to wrap my mind around this warranty deed that you and Jacob are talking about. A warranty deed, when it goes in, you're saying that you just pass that to the other set of criminals, which is the government, right?
Yeah, and they gave you a thank you receipt back, which was your warranty.
Okay, so how in the hell do you own a piece of property without giving notification to the government?
You can't own a property today.
What?
It's not the way it's set up. You can't own a piece of property today. It's being held by
You have to pay cash.
you can't pay cash. You can't pay anything. You can't.
Oh, that's true.
Can't
That's my thinking.
Right.
That's right.
So
You've got to pay Federal Reserve
Right.
notes. I mean, it's only the bank that requires you to go give it to the county.
it's a liar's game. It's a fraud game.
Yeah, they put it very nicely, Christian.
So, in other words, what you're saying is the Bankruptcy Act of 1933 that put a lien against all property has made it impossible for somebody to do a land patent or an allodial.
Not until they terminate the trust.
Okay, what I am trying to get to is how does the paperwork go together in order for that to happen?
Well, that's what we had success at in that one case, and now we're trying to bring it in, get the parties to make a case, bring that into the case. So here are the new results, and get them to go in chambers and present the facts that it's been terminated, the trust, and get them to recognize the perfect title. The perfect title was automatically brought together and formed and became into perfection when you merged the two titles.
Well, why do we
Titles terminated trust also simultaneously, which brought the perfect title back. But now you got to get the public court to recognize that fact.
We can't do it without the court?
No, you need a second witness. Your Bible tells you to establish any fact, you need two witnesses. You got to get the private side and the public side, the two witnesses, to get them to testify what was done.
Well, can you do that like in a common law grand jury?
There is no common law today. It's in trust. Can't get to it. Only in chambers.
There's common law, Chris. You got to be able to get a remedy in payment of dollars for common law to exist. Since there is no money, it doesn't really. It's just a sort of a hoodwink job,
Yeah, right.
isn't it?
It's all fiction, yeah.
Yeah.
Well, when will we be able to look at these documents that allows the two sides to merge? When can we actually start engaging and seeing that so we can wrap our minds around this stuff?
Well, he's given us
Talking about it October last year. It's nothing more
Yeah.
than
I
merging.
didn't understand. Somebody was cutting in. What'd you say?
I've been talking about this since October of last year. It's nothing more than merging titles under the moving titles platform. You take one title, which is a title to the debt, one title, a title to the asset. You merge the two together. What happens? You zero the account under accounting, but you also merge the titles and terminate the trust under trust.
The asset would actually be your claim of right or your allodialship?
My asset is my life birth certificate.
Oh, life birth.
Which represents the real man and all his signature, all his future labors.
So if I was to walk in with a certified copy of my live birth certificate into a judge's chambers, pass that to him along with the debt or the title that the deed of trust is putting claim to, pass that to the judge, he actually will initiate the closure?
No, you have to, and by the time you got there, you should have done that already.
Yeah.
What you need to do is create the records and do a UCC1 claiming those titles, and then do a UCC3 along with the county, and then do a UCC3 transferring, which merges the titles, terminates the trust, and then do the county on that one also.
Okay, see, that was the missing link for me. I could not, for the life of me, for some reason I missed that. For the life of me, I couldn't figure out what the hell the trust res or the asset side was. It makes perfect sense. The birth certificate would be it.
You see,
but I didn't hear that for months.
I can take a cup, and I can form a title to that cup if there isn't one in existence. And then I can transfer ownership of that cup just by moving the title that I created, even though the cup never leaves its place. I can do it with the colorable title that I made up. So what am I going to do? How am I going to make a colorable title? I'm going to say, well, it's a blue cup. It stands so many inches tall. It weighs so many ounces. And I give it some kind of description. And maybe I even put a unique number on the bottom of it, which specifically identifies it. Doesn't that sound like a birth certificate to you?
Yeah.
So then all I got to do is...
In the UCC1, do you have to put anything of the property in that UCC1 with the birth certificate? Would that be evidence? Or do you have to do it manually, taking a UCC1, put the birth certificate in there as your asset,
No.
do a transfer?
Keep in mind that UCC1 is nothing more than a notice filing, and I want to keep it as a notice filing. So the only thing I'm going to put on that collateral block 4 in that UCC1 or that UCC3 is going to be a description of a specific property, which is my trust res, identified by a number, RA 9 digits -US, say.
Okay.
And on the one, I'm just going to put it in the terms that I'm claiming it as mine, and the details are held in private. You want any more information, contact me. Same on the 3, except it's different. I'm not claiming it on a 3, I'm transferring it. So I'm putting a transfer wording in there. I'm saying the same thing. You want any more details? This is being held in the private, contact me.
Okay, so let me get this right. So I've got my BC in a UCC1. I check off box 4. I do a transfer to, would it be a separate UCC for the land patent that I've already set up on the property, and transfer the birth certificate number as a registered mail number?
Yeah, think of it as a trust. Think of it as a trust. Everything is a trust. Okay. And all I'm doing is I'm merging 2 titles, the legal title in the trustee and the beneficial title in the beneficiary, merging 2 titles in one entity. When I do that, the trust terminates. Upon termination, there must be a distribution of the funds. That's the remainder if I'm paying the debt. Upon merging, which is the payment.
So the beneficiary has the beneficial title. The trustee has the legal title.
He has possession and right to do anything with it that he wants.
And legal title, right?
Say that again.
So the trustee has possession and has legal title.
Yes, he has legal title and possession.
Is legal the same as equitable title?
No, that's beneficial title.
Oh, beneficial is the equitable.
Yeah, that's where equity is.
Because once we were using equitable, and then you changed to start using beneficial.
Yeah, equitable and beneficial are the same, but that's in the beneficial.
Okay, thank you. Okay, that's good. Thank you.
Now that trustee can do anything he wants with that property. He can sell it illegally and pull it out of trust, and if he does that, he commingles. So now the beneficiary can come at him, make a breach claim against him, but equity is going to assume he's guilty.
Then what does the grantor get to do?
Well, the grantor is really out of the picture unless he's claimed some kind of beneficial right or some kind of right as a trustee.
Or right to modify?
Yeah, he can reserve that right also, yeah. He's always got that one.
And he can be a co-trustee.
Yeah, it could be written as his will, as indenture could specify that he's a co-trustee. Or he could be a co-benefit.
So if there's a breach of trust by the trustee, then as co-trustee, he can cast the trustee out?
Yes. All in Gilbert.
And what does the beneficiary get to say about that?
The beneficiary is probably going to be happy because if co-trustee is going to correct what the main trustee didn't do, then it's got to be for the benefit of the beneficiary. Because that's why the trust exists. The trust solely exists for the benefit of the beneficiary. He's the one who has ultimate title to everything.
So why don't people then, as the grantor of a trust in a real piece of property, why don't they just modify or take their right to being a co-trustee, and then they just make the payment to the beneficiary of the trust was themselves instead of having to go to court?
Depends on what they're capable of understanding, which position and authority and remedy they've got as beneficiary, and what duty the trustee has, and what obligation.
So did you say that was January the 26th, 2010 was the main finale for going through all this?
Yes, yeah, 126, yes. A through Z.
And since the site's down, do I just get it from one of our comrades?
Yes, I'll give it to you.
Site's going.
Oh, you got it? Okay, all right.
Yeah. If you can't, the site will be up shortly.
Okay, good. I know a lot of people have been asking me, what's going on with it, and I says, well, I know that there was collapse because too many people just laughed. They were laughing in a good way because they realized it's going to be information.
Right. Okay.
Well, we've got a problem potentially from what you're saying. If you are a grantor and you want to delve into the trustee to resolve a problem, you cannot be a beneficiary at the same time. You can never be a beneficiary and trustee. You can be any other combination, right?
Yeah, I would say to keep it simple and don't be grantor trustee or grantor beneficiary.
CW?
Yeah.
In English, there's a rule. What is it? I becomes 4E or whatever?
Except that for C.
Yeah, okay. Now, is there a famous CW rule you could sort of try to make up that...
Yeah, I did when I started the calls about trust. It was, don't be you either want to be grantor trustee or grantor beneficiary. Can't be both.
But can you give us the pros and cons of them, or when you use them and don't, and when you want to be trustee, and when you want to be, GT or GB?
Right. In a court action, I would at that time I was saying that I would be beneficiary in a court of equity. And if it's outside of a court action, then I would want to be operating it as a trustee.
There's the rule. Outside of court, we want to be trustee, and inside of court, we want to be the beneficiary.
Yeah, now since then, we've come up with a new understanding, the fact that it's a discretionary trust per the discretion of the bankruptcy administrator, the U.S. bankruptcy trustee, whether or not you get a remedy. But I could play the trustee role, and I could come into a court now and say, all right, I agree that I am the trustee. Now, by agreement, there is no controversy, so there is no case.
There's no controversy when you agree you're trustee.
Right. So now I'll explain to you in chambers why I can legally not make a payment. So we go into the chambers, and I explain to the judge, okay, if I was to distribute the funds to the beneficiary, since the beneficiary is bankrupt, as soon as I do, the creditor is going to jump on his assets that I just gave him, and that would defeat the purpose of the trust. Therefore, I cannot legally, without breaching the trust myself, make a payment.
And in chambers, you are a trustee?
Yes, I just told him I was a trustee outside in public.
Yeah, but you're going to be a trustee in private too?
Yes, because it's a discretionary trust, and I have a legal right to not make a payment because the beneficiary is bankrupt. That's why I keep saying it doesn't make any difference which position you play. If you understand both parties, whether you want to be trustee or whether you want to be beneficiary, you got a win-win situation.
So after we're in chambers and we express payment, then the judge will view. I mean, is the attorney for the other party out in front in the court, or he doesn't come in private with you, does he?
Well, it depends on how you set the protective order up. If it was judge's eyes only, he won't be there.
Ah. Okay.
This is per judge's discretion in chambers.
Doesn't matter whether he's in there. In a non-judicial state, you're going to end up being the plaintiff, and this guy, this faction representative, is going to be the defendant. But it doesn't matter either way if he goes into chambers or doesn't go into chambers with you. You're still the trustee, and you're going to explain. The judge will have the proof of the trust, and so the judge will automatically discern that the trustee is to make the payment to the beneficiary. If you're the trustee, you're going to be handing over the trust res to the beneficiary itself.
Yes, that's what makes the trustee guilty. She's presumed guilty from the beginning, because.
So you're actually a co-trustee in this situation.
Yes. Yeah. Well, no, I could be the sole trustee, but I got a legal out. My legal out is this is a discretionary trust now, per discretion of trustee, whether beneficiary gets paid any disbursement, because beneficiary is bankrupt. If I paid the beneficiary disbursement out of the trust and allowed the creditors to jump on that and take that, I would be breaching the trust myself. And as trustee, I can't allow that.
Who's the creditor? The U.S. bankruptcy trustee?
Well, whoever the creditors are.
Well, in this particular case,
the past and present debt that beneficiary owes.
It wouldn't be the U.S., Jacob, is what he's saying.
Well, in the case of the mortgage, what I was in context of, the bank is the beneficiary.
Yes, under that particular trust. That's a different trust now. See, we're sliding between different kinds of trusts, and that's a problem.
Okay.
There are many trusts we're talking about, and we're not really identifying. We're switching to another trust. We're talking about that. We're switching back to another one.
Well, I follow you. This is the BC trust. I got it.
Yeah.
Yeah, I understand. So if we switch to a mortgage trust situation, and you're in chambers, and you don't want to be the trustee, you want to make the judge trustee, don't you?
Well, that's what you might not understand. I just said that I've got a legal right as trustee not to make a disbursement, even though when the beneficiary says they made a claim against me, and the court of equity is going to assume that I'm guilty. I got a legal right to claim because it's a discretionary trust. It's per discretion of trustee whether or not the beneficiary gets a disbursement or a payment.
Well, you mean now I'm the discretionary trustee?
Yes.
And it's up to me as the discretionary trustee to give a payment or not?
Yes, per your discretion. Because if I gave them a payment, the beneficiary gave them a payment, upon me giving the payment, the creditors are going to seize the payment. Now that would, by doing that, as trustee, I'm going to breach the trust. Because the purpose of the trust is being defeated. I'm supposed to give the beneficiary the payment. But if I give the beneficiary the payment, it gets seized right away. Does the beneficiary get the payment? No. It violates the trust. So I can't do that. Because the trust is the law of everything. The 3 lines in the case that we did. In the footnote of the 3 lines we put into the court case, it says it's unlawful or illegal purpose. It says in construing trust, unlawful purpose should not be imputed to the settler. And I gave 2 cases on that. And then going on, purpose for which trust may be created. Quote, the intent and purpose of the settler of the truth is the law of the trust. Unquote. That's Edmondson versus First National Bank of Birmingham and 3 other cases. So the law that is in place today is nothing more than the intent and purpose of the grantor on everything happening today.
Ah, okay.
That is law today in place.
The purpose of the grantor.
It's all trust law, and it's all for the purpose and the intent of the settler or the grantor. That is the law today, period.
And that law today that you're speaking of in this instance is pre-1791 law, or?
Can be if you choose your law form that, but if you're in a statutory court claiming statutory trust, then you're under statutory law.
Okay. That seems to to me like I'm commingling a private trust.
We all are. We're all breaching the trust and going to prison and jail and debtor's prison for commingling the trust. You're breaching the trust, every one of us. By having no knowledge and understanding that this is a trust operating under debtor-creditor, you are breaching the trust, and you have to have a license, a birth certificate, to operate illegally in their realm.
Oh, I like that. Oh. You have to, the birth certificate license. Do you have anything on that birth certificate license? Is there a law, or is there some kind of code about that?
Well, you aren't going to find your justification or your knowledge of understanding in the codes. They're all lies.
Okay.
It comes from logic, logos. And that's
Common
word.
reason.
That's word.
Okay, I follow you.
In the beginning was the logos. Logic is a derivative from logos. In the beginning was logic, and logic was the word. The word is logic.
Christian, real quick, what was the end? You said Edmund versus, and I missed it. I was trying to write fast, but I couldn't get it.
Edmondson versus First National Bank of Birmingham.
First
Chris, I have it. I'll send it to you.
Yeah, it's 50 South 2nd, 338, and 352, and 366.
Okay, good. Thank you.
And also Ingalls versus Ingalls. That's also an Alabama case. And Thurlow versus Berry, also an Alabama case.
Thurlow, is that with an E?
Thurlow versus Berry.
That's B-E or B-A?
Berry. And the quote is, "The intent and purpose of the settler of the truth is the law of the trust," unquote. Then those three cases.
And that basically clarifies the discretionary trust and you remaining in a situation of where there's certain things you can and cannot do as trustee. Is that correct?
Well, that's setting the law of the case as being the grantor's will and purpose, his intent. Because in construing trust, it says, unlawful purpose should not be imputed to the settler. That's Hawthorne versus Smith. The purpose for which the trust may be created is, quote, "the intent and purpose of the settler of the truth, which is the law of the trust," unquote.
And that applies to statutory with the inclusion of doing private express trust. Is that correct?
Not under statutory. You don't have a private trust under statutory.
Okay.
I could go under the International Hague Convention ruling there and pull out, I think it's Chapter 2, it says number 1, it says that the grantor has the ability to set the law of the case. And I want to set it for, say, 1776, which is pre-1791 United States formation, pre-statutes and codes.
Interesting. That's under the Bill of Rights, or is it under which document you said?
That's the Hague International. Hague International Trust.
Did that come out of the information I gave you last week?
No, I've had that for quite a while.
Okay. Did you take any advantage out of the information I sent you last week?
I didn't get a chance to look at it yet.
Oh, yeah, well, we're all busy, so there's no blame. Great. International The Hague. Okay, I'm going to have to look at that.
Yeah, let me find it here. If I can find it.
I wanted to thank whoever sent the transcript to me. I appreciate that. That was January the 26th, 2010. Whoever sent that, I appreciate it.
Okay, this is the Convention on the Law Applicable to Trust and on Their Recognition. That's from The Hague. That's the title you want to look for.
Okay, and what year was that, 46?
Yeah, that was 1985 when it was concluded, July 1985, and under, let's see, Chapter 2, Article 6, that's applicable law section, it says that a trust shall be governed by the law chosen by the settler. The choice must be expressed or implied in the terms of the instrument creating or the writing evidencing the trust.
And basically this is a private expression.
Yeah, it could be oral, it could be written, as long as you're making the indenture, choosing the law form. Or I could reserve that for me at any time. Say, oh, that was a mistake. You're construing it under present date terms, and the law of the case is not. I'm correcting that. It's 1776. Sorry, guys.
Yeah. Can you read that title again, Christian?
Yes, it's Convention on the Law Applicable to Trusts and on Their Recognition.
And what I'll do is I'll post it on the group as soon as I dig it up right now.
It's on the website. I got it posted up there, but the website's down.
Oh, okay. So you're going to get that up within a couple days?
Yeah, hopefully it should be up by the end of the week here.
The other night, we didn't get the number of what we're going to call into on Thursday. Is it going to be the same number as tonight?
No, I don't believe so. I think it's might be a different number. So I'm going to contact JC and Eric, and then they're going to pass it on through. So.
Oh, okay, because I haven't heard anything today. I was really busy. I didn't have a chance to end the stuff today. But JC was called today.
Is this becoming more clear to everybody?
Yes.
Yeah. Oh.
Yes, I'm actually very thrilled with this. Now, say for instance, you take your birth certificate, the one from live birth. Would it do any good to put any kind of a tracer or a medallion or any kind of a Q-sub to attach that where you know exactly where that document is at any given moment?
Is the RA number on it sufficient to track it?
Well, I guess you could put one of those on there. And that would become part of the document at that point, wouldn't it? Because it would be under UCC file.
Right. That's the number I'm using to identify the whole thing.
Okay. But you don't actually send the birth certificate into the UCC for it to get filed in there. You just refer to it as the registered mail number. Is that correct?
Yep, that's it. Correct.
Just like I did the security elements?
Nobody really knows what it is except by that RA number and how they're going to identify it as a birth certificate if I didn't tell them. Now I'm really keeping things private, which is the mechanism setting up CCI, Trade Secret Information, because I'm making a physical step to manifest my intent to keep it private.
Okay, Christian, along those lines of things private, who owns the mortgage notes?
Who owns it? The trustee has a legal title to it.
Okay, and we, the so-called borrower, would be trustee, is that correct?
Yes, but also the beneficiary has the ultimate interest and is the ultimate owner. He has the beneficial right or the beneficial interest, the equitable title.
Right. Okay, but I'm asking the question because if the bank or mortgage company takes the note, securitizes it, what position we find ourselves in? Is do we own it or not?
Well, in that particular one, they were the payee as beneficiary, the bank, and the title company was the trustee.
Right, but we're left holding the responsibility to make good for the so-called loan.
Yeah, we're left kind of holding the bag with nothing.
Right. Right. So we have no.
We didn't know it was no support. But that doesn't mean
we were originally the grantor, were we not?
Yeah, we were the grantor. Yeah, but once the trust is formed, the grantor is out of the picture unless he's reserved some kind of right.
Okay, so we really have no claim to the notes.
No, you'd have to come back as, say, beneficiary or trustee, unless you reserve some kind of trustee or beneficiary as being a co-trustee or co-beneficiary as grantor.
So is that by doing a process called assignment, that you reassign trustee?
Yeah, on their mortgage note, that's what I'd be doing. I would be terminating that power of attorney that gave them ability to appoint that title company the trustee, and then I would reappoint the new trustee to be the bank, and since the bank is also the beneficiary, thereby both entities are the same, then the trust is terminated once I create the records that it's been transferred into one entity. Now, at the moment, the trustee has got an obligation to disperse the funds, wind the trust up. He's got an obligation to disperse. And if he doesn't disperse, he's in breach of trust.
So in other words, this does what I was thinking when I was putting papers together, is to hand them to pay back the demand deposit, pay that back in full with the fractionalization and all interest. This will replace that by doing this process. Is that correct?
Merging titles is payment. How else could you terminate the trust? When the trust terminates due to a merger of titles, a payment is made.
So I wouldn't have to do the paperwork you're talking about.
No. You just need to do a trust and create the records, the elements, and the method of formation, and merge the titles, terminate the trust, and if the trustee doesn't do the duty, then as beneficiary, bring a claim against them, and Court of Equity is going to assume they're guilty and can't prove themselves innocent unless they got a record of a payment or disbursement.
Well, what if you take and you liquidate them as trustee, take them out of the picture altogether, reassign the trustee as being a trust under your control, then take your birth certificate and then do a UCC3 transfer and then settle it that way.
Yeah, but if you terminated the trust, that did pay the payment. That took care of all the debts. I would want to make sure that I specify past, present, and future debt.
Okay, Pat.
So once again, from my understanding, if I buy a house with a mortgage note, I have no control, no interest in that note.
Oh, well, yes and no. It depends whether or not you reserve some kind of instructions per the indenture, which was the intent and purpose of the grantor. Or you could come back in and say that everything was being misconstrued here, and as grantor, here's the correction. Everything's been a mistake.
Yeah.
If that's the case, then I could go in and restructure it, and then I could claim notice my trust res and make a file, not a filing, but a notice with CD, then make it my property, then ask them to give it back. Can't give it back, they're in breach, and plus all the money they made and dishonest, correct?
Yeah, uh-huh.
Okay. Now also, someone mentioned a call on Thursday. What is that all about?
This is a one-time call. It's just for a few people. It's just for an invitation. Trust and banking. Another question?
In regards to that word mistake, there's a set of maxims or something that goes along with that, because I've seen this mistake thing used several times this last couple months, and so I'm intrigued to hear what you've got to say about it.
There might be some maxims on that, but I think it's we're using the restatement of the second. I believe it's 345 or maybe 342 without me looking. It says that the grantor can reform the trust based on mistake.
Okay, now where was that again? You said 345, 342. Is that in Gilbert's or where?
No, that's on the second restatement law and trust.
Chris, this is Miriam. I have a question about commercial lien.
Are you talking about Chris or Christian?
Thank you, Christian.
Christian, this is Miriam. I have a question about commercial lien.
Yeah.
I have several commercial liens, and I'm not really sure how to proceed with them. I know that when I collect, I need to have everything ready to put into trust, but how do I collect on it?
How do you mean collect?
Cash them in, get the people that I have the lien against to pay.
So what do you want to? What's your definition of cash? What do you mean? What are you trying to get?
Well, I'd like to have some of those FRNs.
Some of that no money. You want some of that no money?
That's it.
Some of that debt that you think pays something?
That'd be the one. Yeah.
Well, we have to start thinking outside the box, and we have to stop operating in debt. We need to be operating under the creditor side, the credit side of the private, and it's sort of going to be through trust. I'm leading up into that what we were talking about earlier on the show here, which was interest generated on the private side. Excuse me, generated from the private side, but it was deposited on the public side. Because your liens that you're creating are nothing more than debt. I really want to get away from doing debt anymore. Okay, Chris, and going back to that second restatement, it's the restatement on the second. It's number 332, with power of revocation or modification omitted by mistake.
332?
332, yes.
Revocation and what?
It was entitled Power of Revocation or Modification Omitted by Mistake. And that's 332 on the second restatement, Law and Trust.
And just for your information, Christian, in California Civil Codes, there is a power of revocation in the California Civil Codes.
Mm-hmm.
So I would say that every state has a similar layout within their civil codes that would reflect the power of revocation.
Yes, yeah. Okay, I'll get back to the woman's question there about the credit. So, are you going to be using the liens as a special deposit under trust?
Yes.
Because basically, what you want to do is really not cash them in. You want to do them as a special deposit and use them as trust res and make a payment by merging that with a title.
Yes.
And then later
How
on,
do I move them over into that?
interest generated off of something like that. Because what the scenario, what you're trying to do is by trying to get FRNs, you're probably going to be commingling and breaching the trust yourself by doing that.
Well, it's trust res for me, but it's a FRN for the guy that's on the other side of the docket, isn't it? Isn't he going to feel as if he's losing money?
Well, it may look like it to him, but actually he's not. Kind of leads me into something I wanted to talk about, which was really making a payment or merging titles, really, under trust.
So Christian, you have a commercial lien that's acquired under statutes and codes, which I assume this is the scenario with the gal here.
Yeah. Mm-hmm.
Is commingling if you tried to make a special res and bring it into? I don't understand what she would do with it. She would use it as a special deposit to.
Well, she would have that she's doing under the statutory side because it is what you said.
Right.
We're talking about statutory trust.
Guys do use those things properly.
Yeah.
That's why I'm kind of curious.
You see, the problem with those liens is that all this stuff that we've been doing under the debtor-creditor is really under negotiable instruments, because all these are negotiable instruments. Negotiable debt instruments, NDIs. And these NDIs, being negotiable, put them on the public side. And that's not trust. That's not private.
How do you move them?
Payment's got to be a non-negotiable special deposit. We have to turn this non-negotiable or this negotiable NDI into a non-negotiable special deposit and keep it on the private side. And you never want to negotiate it, so therefore you can't ever cash it in like you want to. Because once you try to negotiate, you turn it back into a negotiable instrument and you breach the trust.
So if you have a negotiable debt instrument, are you saying that it's plausible to convert it into a non-negotiable instrument and use it as a special deposit?
Yes, by using a special deposit, you're changing it in from a negotiable instrument into a non-negotiable instrument because you're not negotiating it. And then don't ever try to cross it back over again and negotiate it.
So what's the purpose of doing that?
Well,
your special deposit under trust by merging the title is going to make a payment.
How do you buy your groceries?
Well, you wouldn't want to buy groceries, but let's say you had $100 lien and you wanted to acquire something, and it had a value.
We're not really trying to acquire. We're trying to take, say, existing debt and get rid of it by merging titles.
Yeah, I see what you're saying.
The world
merging the titles.
The world is about $3 quadrillion of debt.
I know. We need a safety valve, and we're the only ones left.
What do you do with it?
Well, you have to relieve the pressure that's been building up by the mounting of the debt. You've got to get rid of that debt. And we get rid of it by merging it with an asset, and that eliminates it.
So let's take one of the world's big problems. Let's say we have $100 billion of debt. One instrument. What would you do with it?
Merge it with a corresponding asset title and get rid of it.
So if I had $100 billion full-blown 5-star hotel with convention center attached and this and that, I could trade it. I could use it as the payment for that.
Well, I'm putting it up against a corresponding title of asset that is going to.
Yeah, I am too. I'm taking a $100 billion debt note for a $100 billion hotel convention center asset.
Merge two titles. Merge the negative with the positive, and that cancels out. We're really not concerned about numbers. Numbers is only under debtor-creditor. Whatever the value is, it's not the value that's anything.
Well, then I just say it's 100 credits of value.
Yeah.
Because if you're going to merge the titles, it has to be something of equal value.
Yeah, but under trust, it's a res. It's a thing.
Well, a thing for thing.
Yes, right. You got to cross your mind over from debtor-creditor thinking, cross it over into trust thinking, and when we're under trust thinking, it's a thing for a thing.
Okay, so I have an instrument that's a debt instrument, and it's big, and I'm under a constraint to use that instrument because of international rules. I I have the hot potato for 30 days. What do I do with that instrument in order to extinguish it?
Turn it into a special deposit under trust and use it as a trust res.
And so I find so I'm going to make, so I turn it into trust res, and now I'm going to go find an asset that I'm going to make a title of the asset, and I will have that title with that asset in it, and then the trust res, would that become that's a title also, right?
Well, actually, this is a lien, right?
Well, not in my case. It's not a lien. In my case, I'm not in that situation. I'm in that situation, and it's actually an asset. It's a debt instrument. Let's say it's a bond.
All right. So it's just a plain promissory or a money order or a bond.
Yeah.
Let's say it's a mortgage security pool. That seems to be the big one out there. Whether whatever type of mortgage, residential, commercial, doesn't matter. But it's a mortgage bond pool security instrument. And so now I have this mortgage bond instrument, and I want to acquire something, I don't know how you say it, of equal value to what the instrument is valued at.
Well, turn it into a thing under trust. Make a special deposit.
Okay.
Kristen.
Yeah.
Go back to her question. Let her finish her question. The lady with the lien.
What's her name again?
Everybody keeps jumping.
Miriam.
Yes. You have another question,
My
Miriam?
name is Miriam.
Miriam?
Yeah. Yes, I do. I have commercial liens that have been affected. I do not know how to collect on them. I don't want to insult anybody's sensitivity. However, I would like to collect on the lien.
Mm-hmm.
And I'm wondering, is that possible?
Not under trust, the way you want to do it under debtor creditor.
Okay. Is it possible in any way?
Yes, in the future we're making this go around and come back around the other side now, and we're issuing credit, or we're ordering interest to be generated on that special deposit, and that interest is going to be put in the public. The interest is going to function as debt, as credit, and it can be used just like checking account, credit card, whatever. But to get to that point, we got to go through all these other steps and come back around, back like the beginning again. We got to make the full circle. We got to complete the circuit, and when we complete the circuit, then the currency flows. Current flows when you make.
Okay. So first, I set up a trust.
We already have a trust.
Okay, and then I deposit the commercial liens into the trust, and then as it gathers interest, I can spend the interest.
Yes, basically, but that's
right.
Very
simplistic.
A lot of steps left out in the middle between getting from there point A to point C, say.
For me, the first step would be, how do I collect on the lien?
Are they secured by anything?
That's the problem. You know, you're thinking under the debtor-creditor mentality. You're in that box thinking, and we got to get out of that thinking and start thinking trust. What is it you're trying to pay? Is there something you're trying to pay?
No, not particularly. I mean, I wouldn't mind having a house to live in, but and I don't care who owns it as long as I have possession of it. But you need FRNs to get possession in the current.
We need FRNs
on the other side of the block. I understand the concept, but I do have a commercial lien. It is perfected. I have 8 of them actually, and I just want to know what is the process for taking that through the system that they currently live in and collecting on them.
Under debtor-creditor, there is no. We've never negotiated any of them, as far as I know, under debtor-creditor. Nobody has ever done any of them. Nor do I think it's possible that you can, because they won't let you.
Okay.
And here we haven't even been successful in even doing set-offs and touching the private side like we thought we were. We're just adding more to the discharge side. It's not get under. coming along and understanding what's really happening. That trust has all along been running the whole show. We need to get to a point past from where we are now with a lot of paperwork and stuff done and a few more understandings of how to generate the interest. Be able to say, okay, deposit that in interest into my LLC held in the public. So it's like, stay tuned. We're getting there kind of slowly. Yeah, debtor-creditor has been around, attacking the remedy towards the debtor-creditor situation for more than 20 years. So, Trust NTT has just come out since last November.
Christian?
I wish we had 20 years at it. Does she have a question?
The mess that we're in right now, if we were.
Miriam, do you have another question?
No, I just heard you say that what I have is useless. Doesn't make any difference whether they owe me the money or not, and it doesn't.
About the only thing you can get is that if you have a successful discharge, in which is you're limited to about a 10% success rate.
So even forcing them into a involuntary bankruptcy would not do anything, huh? Couldn't do that.
Yeah, but what kind of assets?
Contract.
Do they have a lot of assets?
Doesn't mean anything.
Do they have a lot of assets they can liquidate on the debtor-creditor side?
Yeah.
Well, that's possible. You could liquidate them if you could put them into bankruptcy and liquidate them. Yes.
Okay. Thank you.
No, it's not. I don't want to get you disappointed. Success of 10% is better than 0, but as far as I can see, 10% is not a very high rate of anything, especially after it's been out there for so long. We've been working on this for over 20 years or so, and by now I would think we would have a 90% success rate at this, but we don't. And the reason why is because the trust is in there. It's all about trust, really. Discretionary trust, holding your remedy back. Which review of the...
Well, I could see how they...
It was the 126 show.
How can you argue with contract? Is contract law is contract law, isn't it?
But there's no money, and therefore you can't have a contract. We got a trust. It took its place.
How you
really argue a colorful contract and come in under a bankruptcy and win under litigation methods. Yeah, you will get debtor-creditor Federal Reserve notes. To me, that doesn't satisfy me. It's the principle behind the whole thing that gets me. I don't want to just subside in this and contribute more to the debt, because if I'm a Christian, if I do debt on that side, then
all callers are muted. All callers are unmuted. All callers are muted and they can unmute themselves.
So press star 6 to unmute them. But yes, as I was saying, once you realize that if I do credit is debt. If I use a credit card, write a check, generate a profit, use Federal Reserve notes in the public realm, that is debt. All of that is debt. Debt is a sin. As a Christian, you are obligated not to sin. Why are you using debt instruments? I want to get out of doing debt. No longer do I want to do debt. I want to do trust. Because it was a trust from the beginning. God set up a trust with Adam as trustee. And he put Jesus Christ as the trust res. Now if I go around and I violate that, I violate the very premise in which my very belief believes in. I can't do that anymore. When I got a hold of this knowledge, I really struggled for about 3 weeks. I was really depressed about that, because I'm a pastor. When I found out that doing debt, what we were doing in this public realm every day, we don't know how steeped in debt and sin we are. And I had to struggle with that. But I've had to give it up and say, okay, there's nothing I can do about that other than try to get out of it. And that's what I'm dedicated towards and trying to tell everybody else also. You wonder why the Bible talks about money. One of the most things it talks about is money. Debt is a sin. Let no man be under a debt, the scriptures say. Only under the obligation to love one another.
Did you say this is all under the Roman Vatican system of empire building and control.
Yes, it's all commerce, which is all debt.
This whole system is came from the Romans. They're still here. And we are awakening.
Hallelujah. Praise the Lord on that.
But no one said it was going to be easy. I think they said it was a pretty narrow path.
No, we all want to take the wide gate, but none of us really take the narrow gate. We always want to take the easy way out, and the easy way out is really the one that takes you down a path farther than you want to go, keeps you longer than you want to stay, and that sin path gets you in the end.
CW?
Yeah.
The original trust that you're referring to, what was the benefit of keeping the trust in the beginning? What was the benefit?
Glorify God.
What other benefit was there?
God was the beneficiary. We were the trustee, and Christ was the trust res.
Who was the grantor?
God's the grantor. He's the beneficiary. Beneficiary gets the benefit. It's all to God's glory, all to God's benefit.
But we're also co-beneficiaries, are we not?
No, we're trustees on that one.
Yeah, but
we're ambassadors.
Along with the original trust came the understanding of each day you would have a choice to make, and you could choose life or you could choose death. One brought favor and one brought disfavor. The word has...
Yeah, then how is it that it's explained that out of the same lump of clay I created some predestined to noble use and some predestined to ignoble use?
Well, that's the sovereign nature of the designer, the maker, the creator.
Some people think that it's our purpose to serve, and that's where we get our greatest benefit is when we serve others. So you're making an assumption. I would.
So if we do the scriptures according to what God says, who's getting the glory?
Well, each person gives that to whomever they choose. Many people don't give that to the proper party.
Yeah, but I think God has designed a system that looks like we have free choice, but if it was all predestined because He made some for noble use and some for ignoble use, then who's to say otherwise? Do you really have a will that was free to choose, or did it just look like it? You did.
Well, the best example that I use for that.
The point is, let's keep it on a trust basis here, otherwise we're going to get into theology, and that's not a discussion for this show.
Okay.
Christian, just real quick, I did send that out to all of our sites, that International Hague on Trust sets of laws. I sent that out to everybody, so you should have a copy in your Skype windows.
Okay, thanks. Another question? Was that a question?
Let us breathe. It's not time to go yet.
Christian,
I wanted to go ahead.
Christian, the other day you said that you were going to make your law form, and first you said, well, I would make it the Bible, and then you said, or I'll make it the Declaration of Independence.
Well, I think they're one and the same, really. My Declaration of Independence comes right off of the Bible because that's where I was granted unalienable rights given to me by God.
Okay.
From 1776 until present, that's the Declaration of Independence. But from 1776 and back, that's my Bible.
Okay. And that's going to be good for the U.S.?
Oh, we think so. This country was founded on biblical principles to begin with, and look what happened since we got off of them.
So what happens to the rest of the world? What happens to Russia?
The world is.
I mean, is a Russian or a Mexican or a Frenchman or an Australian or an Indian, they're going to they're going to make their law form the Declaration of Independence of the USA?
No, that only applies to America, really.
Okay.
I'm assuming that each country probably has something similar, or something traceable back. At least you could trace it back to the Bible.
Christian, there was two different documents that were assigned executive order that the Bible actually is the foundation for America, and then the second one that was signed off by, I think it was Reagan, made it the international, the Bible was the international, it was accepted as the international Bible of the world.
Mm-hmm.
So you've got two executive orders that allowed that to happen, that was founded out of the executive orders out of the president.
Well, maybe we could use that somehow.
Yeah, I think it was 95-280, the executive order. I think that's what one of them was. And just recently I came across the internationally had assigned the Bible and accepted religious.
Case law to that effect also.
That again?
So can we say that our law form, being trust law, it came originally from trust?
Say that again? Our law form came originally from trust?
Can we say that our law form, being trust law, under whatever you choose, came originally from trust? In other words, the trust law itself, the highest form of law, the foundation of trust law is in fact preceded by trust itself?
Preceded by... Well, if it
originated in, I guess,
was Bible and there was a trust right at the beginning, then really
right, so trust law came from?
A grant from God.
So is that where the trust law came from? Was that original trust given to man?
I think that's where, yeah, because Adam was granted the universe.
So he was entrusted to be a good steward over the earth.
Yeah, it was
Sounds like trust to me.
It was granted to the trustee, Adam.
Okay, and so then trust law came into being?
Yeah, trust res was transferred to the trustee. That's when trust came into existence, yeah.
So in your mind, trust law and trust are one and the same?
Trust law and trust, yeah, because it's per the grantor's intent and purpose, and that first trust was God, his intent and his purpose.
Okay, thanks, Christian.
And his indenture was really the Bible.
Wasn't his indention really the Word?
Yeah, the Word, the Bible.
Christian?
Yeah, who's this?
John, Indiana.
Hey, John.
Howdy. I was wondering what would be the scenario for, like, getting a car to like, go places?
Well, I think the best scenario is to get the debt established first, that you were going to, normal ways. And then if you got some debt, then you can get rid of the debt through trust. But it's really making a payment or merging titles under trust. And if you take that offer for the debt that they're giving you, and on the front side of that, you're going to put like a non-negotiable, say, money order. And you're going to make it look like it's a check. You're going to put the date on there. You're going to put the pay to the order of. And according to that revised code statutes 107.020, where the judge said in that case number, that bankruptcy case, that the signator is really the trustor or the grantor, and the payee is the beneficiary. There's a lot that can be gleaned from that case, because that's really what you're going to be using to prove that's your evidence or a record or a title to prove that who the grantor, the beneficiary, and the trustee are.
Which case was that again?
That's that bankruptcy case, INRI case. It was BK-S-07-16226-LBR.
Okay.
The judge actually said in the footnote, I think it was footnote 31, where it said in there under the revised code statutes Nevada annotated under 107.020, and that's got to be comported to all 50 states somewhere in their local state statutes somewhere. Said whether the judge said that the trustor or the grantor was the signer on the note, and the payee is the beneficiary.
What set of laws is that? Is that trust or is it equity or?
Well, it sounds like he was looking out a trust law, and because he was identifying that note, that mortgage note, the payee was usually the bank that we made out, and we usually signed the note, so we're the grantor or the trustee, because that's what it said for that bankruptcy case. This is going to set up your evidence to prove that there is a trust. Okay, now my thinking is I can use that to my advantage. Instead of putting the pay to the order line or the payee line as being the beneficiary being the bank, how many of you have taken a check out of your checking account, you made it out to yourself, you endorsed it on the back, and you signed it on the front? In other words, you were all three parties on it, and then you took it to the bank and you cashed it. Why aren't we doing that?
Christian, I've got a cross-reference for all 50 states for that particular code. I'm going to put this on the Skype window for everybody. This is a cross-reference into the statute for each state.
Well, that's great, because really that's your proof in your local state where to go and pull this out. And I think it'd be, if you looked under the annotated versions, you'd probably find a whole lot more information and explanation. But anyway, back to the check issue. When you sign as all three parties on that, what you didn't realize is you were turning that into a security instrument. So if I make myself payee on an offer somebody gives me and sign it on the signatory line as grantor and trustee, and I also turn it over on the back and I endorse it the same way that they endorse these mortgage notes, now what happens? And let's go over how they endorse the back on these notes. Anybody familiar with how they do that?
No.
How a bank endorses?
If you look at your mortgage note, some of them will have an endorsement already there by the banks. Where the bank has signed it, they endorsed it on the back or on the allonge somewhere at the bottom. It says they endorse it without recourse. And the next line is the pay to, and they usually leave it in blank. And the next line is they sign it, and the next line they identify who they are signing for in their office. So they usually sign it by CFO or CEO, their signature, and they identify the lender, say being ABC Lender Company. And they leave the pay to line blank, so that puts it into a bearer instrument form. Now, we talked about before on the definition to the Bank Officer's Handbook of Commercial Banking Law under Section 19.02. And again, let me turn to that. And we're talking about CDs, Certificates of Deposit. Certificates of Deposit. All right. Under subsection D, I'm going to skip down in the middle. It says, if the certificate is negotiable, the bank agrees to pay the depositor or any person whom the depositor shall order, or the bearer of the certificate. So when a CD is negotiable CD, the debt of the bank is to the legal holder, that would be the bearer, of the certificate and not to the original depositor. So what we're doing by negotiating the backside, endorsing this way without the recourse and the pay to and in blank, you're turning it into a security instrument, which is really a certificate. And it's a bearer form. And whoever's the holder of the certificate is who the bank is liable to, not the depositor. So this is going to be making a payment under trust. Why aren't we taking some of these offers that people are shoving at us for the obligation of debt or debtor creditor? Why aren't we putting on the top of the front, like at a 45-degree angle, just like you would have the information on a check, marking it non-negotiable, make you the payee, your name on there, you sign it as grantor, and then on the back of it you sign it without recourse and the pay to in blank, and you sign by trustee and your signature, and for straw man account plus social security number without the dashes.
Oh, you mean like a remittance on a statement?
Yeah. Now on the front, you do the same thing where the routing numbers go. You put straw man name plus social security number without the dashes. So this is going to set up the evidence of the title of the records to prove who the grantor and the beneficiary and trustee are by the colorable promissory notes, their money order, but really is all under trust. So this turns their offer, the debt title, into an asset title, and by a special deposit under trust. And also it's also seen as a colorable public security instrument after endorsement. So now you make out the certificate of deposit and also create the two titles of the records claiming and the two titles of records merging the titles as a special deposit / trust deposit, which really is going to become your trust receipt. Remember, that's a record of a payment. And return to the offerer. Then make copies of what you did and send these copies, these title records, which are really a deed to what your act you did, and send all these to Rios at the Treasury on the private side of the Treasury / IRS. So if I made a payment to Best Buy because I walked in there and bought a television set for $3,000 and I wrote them a check, and Best Buy never cashed the check, does that negate the fact that I made the payment and the thing is paid?
Nope.
Nope. What do I care what Best Buy does with that check or if they do nothing with it? If they don't negotiate it, that's not my problem. So in the same respect, I send this person who sent me the offer for this bill this debt, turned that instrument back in, returned it to them as a special deposit with this form on the front, looks like a check, and did the endorsement on the back as a special deposit, what do I care what they do with it if they never negotiate it? But now I send my copies of what I did to the record keeper, the IRS Treasury, on the private side, and if they don't ledger it properly, I tell the IRS, go see them what they did with the check. But in the meantime, I made the payment. What do I care? It's paid. I made the payment under special deposit. I merged two titles. The offer that they gave.
Can you just elaborate just a little more on one particular aspect of converting the debt instrument into an asset to do this process? Can you just go over that one more time?
The offer that they give to me from the offeror is the debt title. But I'm going to turn it into res, so it's just a thing. It's a debt title. So after I put my markings on it, turned it into a special deposit, and returned it back to them, the thing that I put on there turned it into an asset title. So it represents that piece of paper that I returned to them as both simultaneously the asset title and also the debt title. I've already merged the titles.
Very good. I like that.
Now I create the two records claiming that as trust res assets. I create, again, two more records on a UCC3 in a county, proving that I transferred or merged the title. And I made a special deposit, and then I either made a payment, or if that was treating it as a trust, I would have terminated that trust.
That sounds, it's great because it very closely does that mirroring of the accepted for value process.
Although it's not accepted.
No, but it's not. You're right. But here's the part, of course, and it reminds me of something Winston said a long time ago, using a bill of exchange when you've done. He was, of course, operating on accepted for value back then, too. But the part is, on a practical level, because I didn't get the whole thing, what you're saying, but the general idea is is there some place where we can just bypass the vendor, send them a notification, and send this directly to, because this is private, because it's trust, the government, or whoever's the trustee is going to be making that payment and ledgering their account. You see what I'm getting at? Because it's useless to send this stuff to the vendor.
Yes, but I still have to send it to the vendors. And I'm going to send
a notification
to the record keeper, who is going to be the IRS. And it makes no difference. More or less just like the check you wrote to Best Buy. It makes no difference what Best Buy did with my check. It makes no difference what my return back of my special deposit to this offeror. I don't care what they do with it.
Does it make more sense, though, just to send them a notification of that?
No, but I have to send them the original instrument.
Okay.
Yeah, because you're looking for them to execute it in lieu of the government doing it for them.
Yes. If they don't,
exactly. But why don't you wouldn't it be more practical, because we've been through all this stuff with the accepted for value, it would make more sense to say that you're going to do it on their behalf and say that you are going to, they won't.
Well, I am doing it on their behalf. I'm sending notification to the record keeper. He's going to do the adjustment. He's going to go back to them probably and get the check.
Okay. Yeah.
Deposit.
Christian?
They're going to knock on their door and say, "What did you do with that special deposit? We want it."
Take notice and acknowledgement with agreement that this show and/or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and/or guidance by a licensed attorney. This private show and/or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Hello?
Yes, go ahead.
Christian?
Yes, who's this?
Hi, this is Jeff in Washington State.
Hi, Jeff.
So I'm thinking that when we do this procedure, we're putting out, say, $100 in ferns to settle the debt. And after we do it 10 times, we're broke.
Yeah, you could look at it that way.
I mean, that's the same thing that we did with accepted for value, is that we never really got anything out of it because we were putting out money, what we call money, to settle the debt, but we don't get anything out of it.
Yeah, so if we're creating more debt, how could debt settle a debt? So
exactly. So
end up double
even
debt.
doing it this way, I think it's, we should just go ahead and concentrate on terminating those trusts.
Yeah, because the negative liability side, or the title, the liability title, or the debt title, its corresponding value, whatever it is, which is just a res, is going to be the title to the asset. Which is
now, you don't discuss very much about private bank with Mrs. Rios. Couldn't we just do special deposits, especially what Miriam was talking about with her liens? Couldn't we just do special deposits into our private bank?
Yeah, but here we are trying to take a public debt instrument, a negotiable instrument, and, trying to cross it over into the private.
I'm converting it into an asset.
Yeah, I don't think it's going to work that way. I think you have to treat it as a title and merge the two titles, and then it goes to zero.
Okay, yeah. Thanks a lot.
So, Christian, who in the end is making the payment? We're sending it essentially.
The merger of the title was the payment. Taking the offer that they gave me and returning it as a special deposit, merge the titles, that was the payment.
But is there some agency that's going to be, when they get a copy of the statement and the remittance with all the account information?
Well, that's what I would send to Rios on the private side of Treasury, and the Treasury is synonymous with the IRS. She's going to send it on to the proper department, which is probably going to get to the real private side of the IRS.
And then eventually it comes back and they ledger that account and zero it out, right?
Right.
That's the end. Okay. Oh, man.
And do you believe that they're more willing to do it under this trust res and combining this more so than the acceptance for that? Do you think that it's going to be more successful for us?
Yes, because number one, did you negotiate this at all? No.
No.
And if you did, who's the three parties on the instrument? I'm all three parties. I'm signer as grantor, I'm payee as beneficiary, and I'm the one who endorsed it. But it's the bearer form, it's the certificate of the deposit that is, according to the public side, seeable as a security instrument in bearer form that looks colorable enough to them that they know what to do with it on their end. But it's synonymously also a special trust deposit, which is a trust receipt, and that's a record of a payment. And if it is,
and this also collaborates with the international.
It's a record of a payment. Send your record on to the ledgerers or the accountants so they can correct the books, and that's the IRS. It's already paid.
Yeah.
You just need the ledgering.
The ledgering. Yeah. Wow. And that's so close to what Winston was trying to do. That's like going full circle. And he's getting into trust now, big time.
Everybody's getting into trust because of me.
Yeah, I think so.
No, so. Hey, Christian, in regards to the international law on trust that I just dug up and gave everybody, that's your enforcement power that supersedes the United States on enforcement, right?
What's the enforcement power?
The trust law that I sent out to everybody on the International Hague. convention?
Yeah,
isn't that kind of the enforcement power that from outside the United States system is they have to behave because they're following one world order type of government laws?
Well, I think it's more on the lines of equity, where equity is, the power of the trust is in equity.
Christian, is there any issue with being the trustee and the beneficiary when you do that to a remittance?
Repeat that again, please.
Sorry, is there any issue with because you're saying you're being all three parties, like on this example, like a remittance? Is there any issue with being the trustee and the beneficiary in that case?
I don't believe so, because how many of us have taken a check and made it out to ourselves and endorsed it on the back, and we signed the front. We went to the bank and we cashed it. But if we would have taken that check, we could have given it to somebody else, and that was really payment, because whatever was made out for it was what it was worth. It's already endorsed, and all I got to do is apply it.
Can you say, too, in essence, that that's a form of the collapsing or the merging aspect? Is there, too?
Yes, if it was put on an offer, debt title, put your asset title on it. Now you got the debt title and the asset title on the same instrument, and create the records that you merged it.
Now, is this a self-contained process, or does this still involve doing any of the UCC 1 and 3 stuff?
Yes, you also have to create those two records of the claiming of that, what you did, which would be UCC 1 in the county, and then create the two records necessary to prove that you merged it, which is the UCC 3 in the county again.
Oh wow! I'd like to really get this sorted out in my head, because I'd definitely give this a shot. This sounds like a whole concept for sure, and I don't think I've ever heard it quite like this before, ever. Like, this sounds like it's got all the pieces.
You got to sign it without recourse, and you got to put pay to and leave it blank, because it's got to be an in blank. It's got to be in bearer form, and you got to sign by trustee in your signature. And then below that, you got to put for, and then you got to put the straw man name in caps plus the Social Security number without the dashes. So that's for the trust. You're signing as trustee for the trust. In the front, you've also got to have the corresponding same account numbers, which is the straw man all caps plus the Social Security number without the dashes again. That signifying the account or the trust again.
Do you think there's any requirement to say exempt from levy?
No.
Okay.
Levies on debtor-creditor side.
Right. Oh, yeah, there you go.
Christian, have you got an example of that check you're suggesting?
Yeah, I do. You on Skype?
Yeah.
I am.
I'm on the...
Why don't I give it to somebody, and then they can, pass it on. See if I can... somebody give me... Chris, are you going to be on later on tonight?
Yes.
Because I'm not on Skype right now, but if I do, I might crash what I got going on right now.
Yeah, if you send it to me, I'll send it out. I probably have about 50 people in the 3 different windows. I've got CR's Assembly, Topic on Trust Group, and Trust on Topic. So those 3 groups got about 50 people that join us on these calls that'll get it.
Okay, give me your Skype number.
Handy Summers.
Handy
Summers.
SUMMERS.
Is that you, Jacob?
Chris Summers?
Yeah.
Did you put that at Law Learners too? For those that are on Skype?
I think it's already posted. From what I understand, Darren posted it.
At Law Learners?
Yeah, he had to update it because everybody was giving him all the communications from me, and he... I told him, I said, just put my information up there for everybody. So I think he did it. I haven't been over there since he was supposed to do it.
Okay, I'll look for it tomorrow. I'm talking about this check example.
I just hope that it comes with a complete context of information, so that people are not just parroting the words on the paper and then trying to push it through and making all the other stupid mistakes that comes back as all the reasons why it doesn't work.
Yeah.
You know what I'm saying?
Right.
Yeah. And just for everybody's information, I work on a newsletter for law learners, and it's posted on Sundays for Monday. But you can always Skype me for the newsletter during the week. And all this stuff that we're talking about, as I dig it up and pass it to you guys, if you happen to miss it, just ask for the newsletter. All this stuff is posted in the newsletters for the week.
Cool.
I just have it across the top. It says non-negotiable money order number 001. I put the date off to the left, and then under that is the pay to order, and there's where the payee is. That's the beneficiary, and there's where I put example your name in. And on this one, I didn't put a dollar line on there, but I put that in there later. But then below that is this. On the left is the straw man account, all caps name plus the Social Security number, and that's without the dashes. And on the right is the signature line, and that's where I would sign. That's the grantor or / trustee, because grantor is acting as trustee there.
You don't want me to put that on the newsletter, though, do you?
No, if somebody gets a hold of this, they'll be,
Yeah, I won't put that in there.
Yeah,
I'll just pass it on to them.
it's for everybody's review, let's put it that way. And on the back side, it's signed without recourse. Next line, pay to, leave that blank. And the next is by trustee, and then the signature line where you sign. And then below that is for straw man plus the Social Security number, again without the dash.
Okay, can you put that on a purchase contract?
Yeah, but I have to know more about trust to say I'd go out there and try this, to go out and buy something with it. So in the blocks I got in here, the description, in Nevada Revised Statutes 107.020, the judge in the case number, and I gave that case number, said that the signator is the trustor / grantor, and the payee is the beneficiary. So this sets up evidence, and evidence is really the title or / records, to prove who the grantor, beneficiary, and trustee are by the colorable promissory note or money order, but really it's all trust. So this turns their offer, the debt title, into an asset title, a special deposit under trust, also seen as a colorable public security instrument after endorsement. So you make out a certificate of deposit, also create the two title records, two titles / records claiming, and the two titles / records merging the titles as a special deposit / trust deposit as payment. In other words, merge titles. So, and return to the offerer. Then send copies of what your title / records, the deed, to what your act you did as send it to Rayos at the private side of the Treasury / IRS.
So that's almost a self-actualizing set of documents.
Yes. Comes in the creation of the records, the two records to prove everything that you did, two records to prove that I claimed it as being mine, and two records to prove that I merged it.
So that would be, the two titles would be UCC1, and the two merging would be UCC3, is that correct?
Yeah, the merging is on a 3, and the claiming is on a 1, and each one has a county correspondence notice with it.
Okay.
And don't confuse that UCC1 as being like what that other party was telling them back last week. They saying they were having problems recording the UCCs in the county. We won't record UCCs in the county. That's why they were having problems. They don't get recorded in the county. You make up a separate notice that gets going, that goes into the county.
And where the first notice goes?
Well, the notice is nothing more than a record. To prove
So where's the UCC1 go?
Well, what
filed with the
I would,
Secretary of State, doesn't it?
yeah, I'm just keeping it in case I need it to prove that it was mine. Because at first I got to claim it.
Well, it's not going to Secretary of State.
Well, the copies would be. The copies would go to the Rios.
Oh, in the original, which is the rule form, and a copy would go to the Secretary of State of UCC1, and then just a notice of that UCC1 is reported in the county.
I'm going to do a UCC1 claiming this is mine. That's one
and
notice.
The copy to the Secretary of State.
Copy. And I'm going to do UCC1 filing. I'm thinking I could do it online. You're thinking, well, I got to send the UCC1 to the state. Yeah. That's one notice. Pull out a certified copy.
And how do you pull that out?
Request a certified copy. Pay the $10 or $15 for a certified copy. And then do
Now you make a notice of that notice to the county with the certified copy attached?
No. Do not record anything from the UCC into the county. They won't let you.
A separate notice.
Yes, do a separate notice. Just put on the top notice. And then this is constructive actual notice that document, like I read, was it last night or the night before? I forget.
Yeah, RA blah blah blah.
Yeah, claiming. And if any other further information is needed, contact.
And or address, right.
Right. Record that into the county. Pull that back out certified. Keep that. So now you got 2 records. You got a UCC1 certified copy. You got a county recording certified. And there's your 2 records to prove that you claimed it as yours.
Got it.
And do the same thing with the 3 UCC3 and do another county.
2 more records.
Yes. You keep the originals there.
Yeah.
Never keep the originals away.
Are the originals for in chambers?
Yes. Now you can make copies of all that stuff and then send that to Rios.
Do I have to?
Yeah, but they're your accountants.
Okay.
Got to complete the process. How does the accountant? How do you you give it a document?
Know who I am.
Paid it.
Christian?
Yes. Who's this?
This is Jeff in Washington State again.
Hi, Jeff. Go ahead.
I found out today from the federal court, district court in, it's actually in Seattle, but my local one is in Tacoma. And I can open up a miscellaneous file there for $39, and I can put in as many papers as I want, and I can pull out a certified copy for $9.
That's good. That'll save you some money then, as long as you're creating a public record.
Exactly.
What state's that in?
Washington. Tacoma.
I can echo that in California. This afternoon I did the same thing, but I had a notary put in a proof of filing attached to each document. First was the birth certificate expression, and then the second one was a transfer when I became of age. I put them as 2 separate documents, each one with an attached notary proof of filing. And the same experience in California. $39, and it was really refreshing, very nice about it. They're great people to work with.
And what's the web address for that?
Web address?
How do you find that party?
Just find your local federal court.
It'd be the same in all states.
There's one in every state.
For you, Jason, that would be San Diego.
Mm-hmm.
Oh, by the way, the way you do that, they do not require a cover letter or anything as a prerequisite. What I put in there is notice of trust is the first document on the heading, and then I went ahead and listed it, and it was parallel information to the UCC1. If we had a place to post these things, I'd be happy to send out a sample of the template.
Well, if you send it to learnlaw@comcast.net, or if you're on Skype, send it to Handy Summers. I'll make sure everybody else gets a copy of it.
Okay. I'll see if I've already sent it to you, Chris. Either way,
right. Who's speaking, by the way? I recognize your voice, but I can't place a name.
Daniel Ray.
Hey. Yeah, okay. All right, now I got you. All right.
Hey, Christian, this is Terry.
Hello, Eric. Go ahead.
Terry in Louisiana.
Terry.
I have a question for you. Stepped out of the room in the middle of your explanation of this. Can you tell me if anyone has attempted this and or succeeded?
Nope, that's fresh off the press. Nobody's tried this yet.
That's what I thought. Thank you. Appreciate you explaining it.
In other words, you're going to be the guinea pig.
I'm going to start working on it tomorrow.
Happy guinea pig. Hey, Christian, were you going to send that check? Everybody's asking me for it on the Skype.
It'll have to be after the close of the show because I can't stop.
Okay, all right. So everybody, did you hear that? You're going to have to wait until he sends it to me.
So we just put Handy Summers on Skype?
Yeah, you'll come right up with it.
Okay. And where are you going to post it?
Well, I got a recording running right now, and if I brought up Skype, it would probably crash the recording, so I can't do that. So I got to save it.
But when the site comes back up, then we can hear it, right?
Yeah, right. I've got all the.
So you're going to put this evening's program up on the site?
Yep, as soon as I get it back up again. It was about.
Well, I've got a recording of this evening's too, so if anybody wants it sooner than that, let me know.
How do we contact you?
Handy Summers on Skype.
I'm not on Skype.
Oh, well then you'll have to wait until he posts it because I can't send that big of a recording through the email.
Understood. Thanks.
Okay, any other questions? Any other things?
Christian?
Yeah, Carlos, go ahead.
Hi, how are you? Good. You were talking about the stamps on the note. I know I mentioned to you already in some other calls. I've been speaking about it. My brother's note has 4 stamps. I mean, that's nothing new, but just things a little clearer. Has 4 stamps stated to the order of Lehman Brothers without recourse, as you were stating about a few minutes ago, right? Now, why do they stamp it, or did they get the money and stamp it, or that's where I'm lost. They stamp it for what reason? I obviously make money.
Well, they turned it into a security instrument by endorsing it.
Okay,
and
4 times?
That, by signing it in blank, made it a bearer instrument.
Okay. My question is this. Why 4 times did they do it? They get paid 4 times, obviously, right?
Well, I think they got paid much more than just 4 times.
Well, yeah, because the one I'm talking about, it's a forgery, because that's not my brother's signature. We're already filing federal lawsuit on that, and we're gonna start federal, and then we're gonna go RICO to that. But that's beside the point. What I did not understand 100% is when they stamp it with that stamp that it says whatever we know it, they make it a what did you call it?
Security instrument.
Security instrument, right?
Yeah, they moved it from Article 3 to Article 9 under UCC.
Right. Yeah, I learned that from TT. Right, Kitty. Okay. Now, did they have to move that out of their possession, or it stays in their possession? That's what I don't understand.
Well, they securitized it. They put it back into a trust so it would earn some more interest. The trouble is they kept the interest and stuff. You know, they got paid.
Yeah, they kept everything. Right.
So they're really taking good care of it because it's your special deposit. They know that. It's under trust. They know that. And they're keeping it invested for you. Except you're never claiming the asset.
Yeah, well, until now. But basically, every time they stamp it, because they stamped it, I want to sound like they stamped it 4 times. Every time they stamped it, they did a conversion, right?
Yeah, it had to be at least an allonge on there, probably with at least 3 signatures or more, if it was securitized.
Okay, if it was securitized.
It had to go from the originator to the what's the title of that one guy? I forget the position. Successor? Yeah. And it goes from the successor to the agent, and then it goes from the agent to the depositor. So that's be three endorsements on there.
Okay, now, I'm not sure my brother has that copy, but I'm sure there's a copy. I'm sure they made money. We all know they made money with it. I just want to get a clear picture on it, because we're suing also the person one of the signers that signed right in the center of the stamp, where it says without recourse, we pay to the order of Lehman Brothers, and then it says Vice President, and he signed it, Secretary signed it, and some other fellows also signed it. We're suing all of them.
Okay.
Because one of them had
2 line, which was not blank, they had an actual company in there?
There's one line, I'm sorry, there's 4 round stamps, and in the middle, they signed it. That's all I'm seeing. I don't have all the documents in front of me because my brother has it, but that's what we have. And on my brother's, it's printed name. Somebody signed it as his brother did, but we know it's totally different from the signature. So we're gonna get someone who does professional, who verify the professional signature, tell us when certified that it is a forgery, and we're doing a list pendants to the bank, and everybody that signed it. I mean, everybody who signed that document.
Yeah, all I have to do is make a prima facie evidence case that's not yours. Just put up an affidavit that you say that's not yours. That's all you got to do.
Yes, I was going to say, the only one that actually can deny is the alleged signer himself. An expert can't tell you whether that is signature or not.
Yeah, because I learned from a good fella, he's well known around it, I don't want to mention his name. He says that even if I have the court bring someone to verify that signature and verify whatever is written on that document and whatever the other person writes like.
But Guy, you're missing the fundamental point. That's your signature.
Yes.
Classic Sam Kennedy. You're the only one who can qualify. You're going to make yourself look like a fool bringing in an expert to say that you can't say yourself. You need an expert to tell you what your signature is.
Okay.
You're the only one who can prove what your intent was.
Okay.
This is,
Yeah. Okay. Thanks. I'm overkilling it. Okay, I understand. I mean, that's why I'm here on the call. I mean, if I thought I knew everything, I wouldn't even bother saying something about it. But I'm not bragging. I'm just trying to relate to the guys. And thank you. Thank you.
It's a very powerful argument.
I just went through one of those myself. It was on actually a title to a car, and the penalty deadline, and so he forged my name, and then so I sent to the DMV an affidavit, and that it wasn't my signature, and then they said because I wasn't a valid, such and such, they use an excuse, whatever it is, that they couldn't accept the paperwork.
Just to return a process, maybe. But the principle is the thing to focus on. How you do it is another issue.
Christian, I have a question in regards to the bank. When they have you sign these documents, when they do not express that it is a trust, isn't that a violation of trust laws, that it has not been properly expressed? Therefore, it takes on a different nature other than a breach of trust?
No, it's up to the grantor to express the trust.
When you're signing the papers to get a loan?
Yeah, they're going under the assumption that you know it's a trust, although they know that you don't, because none of them know it's a trust.
Yeah, but isn't that kind of like in trust law? That's it's got to have something there for us to sink our teeth into.
Well, that's the whole thing about trust, because no party in the trust needs to know that a trust is being formed, including the grantor.
That's the bingo. That's the bingo, Christian.
That's how they get you with the straw man trust, because you didn't know that there was a trust being formed, the straw man trust. That's the real deception about the trust. That's where the real power comes in, because now they know what's going on, but you don't.
Yeah. And it's all their paperwork. There's nothing that you actually added to it except for your signature.
Right. The grantor was supposed to be the one who is expressing the trust, and he can express the trust even without him even knowing it. He doesn't have to know or understand that a trust is being formed. Although he's operating as the grantor. He's forming the trust. And they're tricking you into getting these trusts formed. You're forming all these trusts. You don't know they're being formed.
Christian, you mentioned that was the bingo, right? The biggest bingo? One of the biggest ones?
Yeah, that, and then the fact that the power of the trust comes in, the burden of proof shifts once the prima facie case is made by the beneficiary. The court presume that the trustee is guilty from the get-go.
Well, what was the name of that case around the 107.020? What was the name of that case? I missed that.
It's Credit River.
No.
Is that the...
No, that wasn't Credit River.
No, I don't think it was either.
In Nevada. Mitchell in Nevada.
Mitchell, Nevada.
Stephanie and...
That Christian site when he pulls it up.
Yeah.
Okay, but under that 107.020, wouldn't them not expressing that it is a trust be a grantor's wishing well to change out the trustees and the nature of the documents at that point?
Yes, because you could say, I didn't know about it, but I'm the grantor. This was all a mistake. This was not my intent.
Yeah. Okay. Good. Great. That's what I was looking for right there.
That's under that 332 second restatement of the law and trust. You can come back in and say it was a mistake and reform anything.
Christian, anything else that you would advise us on that, going back to that note on brothers, that when we're fighting the federal lawsuit and going up to RICO? Anything else that you can think out of your head, out on the top of your head right now?
Make sure that you got the records and you're forming the trust so you can prove the trust.
Well, wouldn't you file a federal lawsuit against that person in the bank due to the fact that it's forgery? And I think it's 513.
Oh, forgery is hard to prove. I would stick with debt validation under 9-210A4.
Okay, going back to the same theory.
Fraud, you come at them colorably against with fraud, is you got to have a heightened pleading, and fraud is really hard to prove, really. You almost got to have exculpatory evidence.
Have you tried to settle with them outside of court first?
No, we just started right now. We got some help from someone that offered help, documents. No, we're delighted about it. We're happy, because eventually something's going to turn out good. But I'm sure they're going to try to settle.
Okay, something I thought of when you were mentioning that before, which reminded me. Have you claimed the note?
No, we have the note.
Oh, I didn't say claim.
My brother paid the loan off, and they send them the note stamped.
No, wait. Have you put the document records together, the two titles necessary that you claimed it? Have you claimed the note?
No, I was talking about something else. Sorry. Okay, I'm sorry. Let's start over.
Have you filed a UCC-1 and you've done a county, 2 records claiming the note?
No. Doing trust law, no, we haven't done that.
Oh, well.
My brother went straight to the lawsuit. But that's what they advised him, and that's what he started doing. We got somebody else helping us, and he says, well, actually helping him because it's his note.
So you're dealing with the lawyer?
No. Someone else helping him. He's got all documents, and they started civil. They're going to go up in RICO. Once they start, they're going to do an addendum RICO.
Maybe you want to deal with somebody in this group and take it from a trust point of view, I think is what Christian's trying to say.
Okay.
You got to start exercising this concept.
Yeah, that's what I told my brother. Yeah, exactly.
I would create 2 records claiming and 2 records of showing a merger or merging the titles, and then I would come in and I would do the debt validation stuff simultaneously. And when I got that all done, then I would order the surrender of the note.
Well, Christian, let me get back to you. That loan is paid off. He has the note in his hand. They send him the original note, stamped, forged.
You sure it's the original?
Well, yeah, it is the original. I'm sure because you can feel the signature, but it's not his signature, somebody else's signature.
Well, by definition, it can't be.
They recreated an original.
Yes, exactly. They recreated an original stamped 4 times. That's why we're going for forgery.
So why would he claim that, Christian? I don't think he claimed
but that's also identity theft.
Yes.
Yeah,
also.
that's your deal.
It doesn't sound like you can do anything with trust, so.
Yeah, I don't think he should claim that.
That's a whole other issue.
The Attorney General has got huge cases of identity theft going right now on everybody.
That's about fraud, basically.
Yes, that's what we're going for. We're going for fraud. I think that's 513, USC Title 18, 513.
Okay, has there been a power of attorney created by the bank allowing them to use your signature?
Yeah, Christian, but we did not allow them to forge our signature.
That's right.
We gave them power of attorney.
And number 2, you can't do it on the note. That will come after the note. The effectiveness of the power of attorney will come after the note.
Exactly. Supposedly my brother signed it, but that's not the signature. You can see it from a mile away. That's what we're excited.
He's saying, did you give him power of attorney to sign your name?
Yeah, but not to forge my name. They're
just trying to bring up an issue of interpretation. We're trying to figure out what the bank's angle, and it might be some colorable stuff they're doing, and he does got a case if he can properly understand it and understand how he wants to go at these guys. He's got to get it sorted out.
Yes, there's actually a gentleman that everybody knows. He's but I don't want to mention his name. He offered his document offers to help us and to mentor. So my brother decided to go ahead and file a federal lawsuit, and we're going to do an addendum and said, if you do RICO at the beginning, they won't let you, but if you do it this way, do an addendum, then do RICO, you're going to get some money for sure.
Hey, Carlos, they did the same thing to my mom. When my mom signed a deed of trust, her signature, which is the same identical signature, even as far back as my birth certificate, matches up with the document that she had signed. Well, the one that they had filed at the county recorder's office is a completely different document, and the handwriting is very short and stubby, and it was really hard pressed, like somebody was trying to copy her name. It's a complete forgery that they had filed at the county recorder's office, completely different than the one that my mom had signed that got a copy of it at the time of the signing.
Yeah, we have the identical problem. Again, I don't want to sound like a broken record. We have the original, supposedly, like Carol said, he brought a good point.
But just to emphasize again, though, the bottom line isn't all the gumshoe detective stuff. It's you are the only person qualified you're the only person who can qualify that signature. And you got to understand that. That's it.
Yeah. Right.
You understand the power.
You're the only one who can authenticate it.
Yeah, but CW, do this in a different matter under trust and use the violation of intellectual property rights?
Or he can go in under breach of trust.
Yeah, maybe.
Yeah.
Because if they had the power of attorney, they were actually acting as a trustee. And they went in there and breached the trust.
one way of looking at it.
Well, you haven't established that though yet, so you're making assumptions again. Like you,
Well,
now
the only
you're
one who can
getting
establish
close.
it is the beneficiary, and that's easy to do. All you got to make is a prima facie affidavit, and that's it. File a case against that. That's easy. The cause of action, breach of trust.
And the UCC stuff.
Yes, because you got to claim.
Now, when you do that,
equity.
when you do that, how do you what do you get out of it?
Breach
What
of
get out of
trust.
Breach of trust, that's a tort claim. You can pay for that.
I'm going to get at least treble damages plus compensatory and punitive damages on the colorable side.
Correct. And being that it's breach of trust, in equity, they come down hard on trust.
Treat this as statutory trust.
In jail.
But it's not a breach of trust until he establishes it as such.
No,
Right
he
now,
all he has to do is make a prima facie case, and now it's up to the trustee to prove that it isn't.
the
Yeah,
cost.
Christian, stepping aside for just a bit, I know everybody's tired of foreclosures, but just to get, we're going to step aside to something else. Why wouldn't you assign the bank as a trustee, and they are the beneficiaries, therefore the trust collapses automatically?
You could do it that way.
Yes, that's what I thought.
You what?
Oh my God.
The bank is the beneficiary automatically because of the payee on the note.
Yes, I think, to me that sounds a lot easier. I mean, that's me.
There's a trustee appointment, which was usually the title company. Pull that power of attorney, get rid of them, and then appoint the bank also as trustee. And they're
That's what I
all
want to do on my
beneficiaries. So now they're both entities.
Thank you.
And he can do that because he's the grantor.
Yes, once he establishes that he's the grantor because he made the claim, proved the trust, and
then
he was
establishing that
grantor, and he's appointing
Yep.
because of mistake.
We already have a trust, which is the deed of trust. I mean, they know better. I mean, we know better. I'm just making a substantive trustee, and since I like the bank so much, I'm gonna also sign him as he.
Yeah,
That's
the
how I'm
two
gonna-
titles to prove each one, and then you make the claim, order the note surrendered.
Yes, right.
Hey, Carlos.
Do they have to accept being a trustee, the bank?
They have to.
They'll have.
Can they refuse it?
Yeah, if they refused it, then you'd have to go to a court and have the court appoint somebody else.
Hey, Carlos.
Yes.
Hey, don't forget the fact that what the banks are doing are defrauding the United States of America and the state of California, of which has put an economic tragic throughout the state. Now, why in the hell isn't the state moving forward on filing criminal charges against these people? I think you need to talk to the Attorney General's office to see if they'll move upon that. You've got proof in the pudding that these guys are doing criminal acts that is affecting the economy in California.
That's funny because my wife's niece, they sold her house at a trustee sale in December. I sent only one letter to the district attorney. Everything's frozen. I know they're not going to come back. They put me in the back burner or in the soaking department. I know that, but they gave me time to work. Just by sending one letter to the district attorney, froze everything.
Christian, if the bank refused being trustee rather than going to court, could you make the Federal Reserve the trustee?
Federal Reserve. Well, first, I don't think the bank is really going to have the wherewithal to make a disclaimer formally. I think they're going to time out, and you'll have it by timing out. Now,
I
Federal
think
Reserve
your idea
trustee.
of merging the titles is excellent because we're already saying that the Federal Reserve has dropped down funds to these banks. The funds are there. All we have to do is bring them forward, close it out, send it up to the private side of the U.S. Treasury. It's a done deal.
Right.
Because otherwise, if you're drafting these bill of exchanges or bonded promissory notes and you're passing that acceptance for value up to either the CID or the IRS or the U.S. Treasury, what you're doing is you're double paying these criminals running the banks.
Mm-hmm.
You're giving twice the amount of money by doing that. Instead of closing accounts by using this trust method that you're saying, that means they can't go any further. It's a done deal. So I really do like this. This is great.
You're drying up the debt. You're not creating any more debt. You're not doing debt any longer.
Yep.
But isn't there a trust between the bank, the beneficiary? Isn't there a trust between the bank and the Federal Reserve?
Yeah.
Probably a statutory one.
Yep. They're tied at the hip.
I'm sure they have both. They probably have a secret one and a public one.
What if we 56 and made the IRS the trustee for the BC account.
I think Reservo runs the show.
I think you're going to have to get rid of your own appointment as you self-appointed yourself trustee first. Then you could probably get somebody else.
Won't the IRS or somebody be a successor trustee? By appointment as the grantor?
Yeah, but successor then, yeah. Once you got rid of your own self-appointment.
If you,
here's where the rub is in our statutory trust. You can't, once you've accepted, you're stuck with a position unless you got a court order.
Missing piece.
And then you have to find a successor. That successor has to be accepting, and then once he accepts, then you can get out. So that's why I say we need to review last Wednesday's show when I talked about trustees' liabilities and beneficiaries' remedies. And I think the Wednesday before that, when we talked about more on the administration of the trust, according to trustees' duty.
So the last Wednesday?
Yeah, last Wednesday and the Wednesday before that.
Okay.
That's what I was saying on the call last night, that there were some things I could see that, there was a basic misunderstanding, and we need to go back over the basics again on those people who were talking. Now, there were some other people who were listening that were probably more advanced, like Rhonda came on and took offense that, was saying that everybody should go back to basics, but it was the people that I was talking to that were talking out there. They were the ones that needed to go back and review things.
Christian?
Yes, who's this?
Floyd.
Hey, Floyd, go ahead.
I just want to know, is it okay if I ask Shane a question?
Yeah, go ahead. All right.
Yeah, Shane, I wondering, are you going to send out those two letters that you said on the other night?
Didn't anybody get them?
I didn't get them.
You sent me an email?
Yeah.
What's your email?
Floyd_Howell@yahoo.com.
Oh, hold on, Floyd. I'll check it. Anybody else get them?
No, I didn't get them either.
I got them.
Yeah, I got them.
You got, hold on. Somebody should have got two, actually, because then I grabbed all the emails and sent it out twice.
I got two.
Okay, so a couple people got them. Okay, because you can see all the emails on the list there, guys, right? I put it all in the front. Just double checking here.
Yeah, I did see on the second email you put all the names.
Okay, so if you didn't get it, I don't know the emails because I just sort of got them as they come in. But and just in case, if someone can cover me there, that's Chris speaking out there, right?
No, that was Floyd that was asking for it, but I did not get them. So if you send it to learnlaw@comcast.net or Skype it to Handy Summers, that'll be suffice.
Okay, can you send me an email to sigma6@hotmail? That's a little easier for me.
Okay, that's SIG.
Yeah, Sigma, SIGMA, 6, the number 6.
Okay.
Sigma 6, that's it.
At Gmail?
Yeah, Hotmail. Or Gmail. You can do Gmail, but do it Hotmail.
Okay, Hotmail.
Christian?
Yeah.
That dot.
Does our signature, when it's placed on a credit app, no matter what the credit app is for, is that tied to the birth certificate?
Yeah, all these signatures are trying to get into the account.
That's the bottom line reason for dealing with the birth certificate trust thing that you're talking about getting terminated.
Well, no, terminating is really the payment. So I need to merge the titles, which terminates the trust. That makes the payment.
If you terminated the birth certificate trust, what would happen if you sign your name on a credit application after that?
Can't operate in commerce unless you got some kind of interface, like through that LLC. And then the LLC's name is like my name, all in caps, with a new number on the back.
And you'd have an EIN number, you mean?
Yeah.
Is there a way to go ahead and create the LLC now? And is there a way through, like say if you were to get an insurance policy or some kind of security on your birth certificate, is there a way for us to get an insurance policy on our birth certificate?
Is there a way to get an insurance policy on our birth certificate?
Yeah, so that it becomes an asset that we could put it into the LLC right now where it would have credit?
You're like saying, well, can a trust help a trust? Sure.
Well, can a trust act as an asset that will start generating credit from it?
Yeah, but what my trust is really my word, and my word is my bond, and what I say, that is an asset. What's my word, my signature on a money order?
If I were to take my birth certificate and put it in an LLC and attach a value to it, and then put my LLC with the Dun & Bradstreet number, I would now have instant credit.
Well, now you're starting to think a little bit of how things could operate. Yeah, that's
I am.
kind of possible of that. But now you still got all kinds of debts and obligations that you're connecting back into that account, which you haven't taken care of yet. So what are you doing?
Yeah.
Creating more debt on the public side. That's not too good, really.
Okay. I'm just trying to brainstorm to see how this eventually is realistic.
Yeah, so you're puffing the debt up on the public side, creating more debt instead of getting rid of the debt.
Well, I would use it as credit, not debt.
Two Faces of Debt by the Federal Reserve publication says debt is credit, credit is debt.
Oh, yeah, okay.
Debt is what we're using as money in this country today, in a democracy, the United States.
That would be two sides of a trust right there, the asset and debit.
They're just using the debt side of it, though.
That's right. But what if you take a birth certificate, like what he's talking about, and put it on a Dun & Bradstreet as an LLC, and then you leverage shares against the birth certificate?
Yeah, but you're making more negotiable debt instruments, more securities, more debt. You know, you go out there and write a money order. Write a money order against the birth certificate for as much as you want. We got an unlimited ability to create much debt as we want.
Well, what about doing that for some kind of like gold or silver? It's kind of like a purchase.
Yeah, but then you just created a counterbalancing debt that represented an asset.
All right, I got it. Yeah, I finally just snapped.
And then also, what if they were to connect themselves back again with U.S. Trade or Business?
Yeah. Mm-hmm. Big
We
part.
also talked about using the certificate as a copy of the certificate is a instrument to sign off against a debt, like a court debt or something else.
Well, like we were talking about with NEXE, the birth certificate is, the payment because it was a special deposit. Only because we were treating it as a special deposit under trust. Where are you guys talking about any kind of trust? Nothing. You didn't talk about trust.
Well, can you put your signature in as a special deposit as an asset in an LLC?
Yeah, you'd have to have a trust first and then have the LLC offer the trust.
So the special deposit is in the trust, right?
Yeah. Again, is it effectively connected with a business or trade in the United States? What is its source of, where does its source come from?
Well, that would probably work in that lady's favor with those commercial properties.
Not until you get to private.
And it depends, I guess, where your birth certificate is from, where the source is.
Yeah, have you claimed that you're a non-resident alien and the source of the birth certificate is private?
Yeah.
How'd you do that?
Because I have both. I'm a very interesting guy. I have a birth record and a birth certificate. I have two identities. By accident. At birth. I have one birth record where I was born outside the United States. I have another birth certificate where I'm born inside the United States because I was born in a territory. And it was an illegal territory, and it was before it was a state.
Okay, two fiction titles.
One's a birth record with my signatures, my two footprints. I have the original two footprints on the back. I actually have the original document. And then I have the state, like you said, I think they go ahead and make one up whether your parents do it or not. Because years later, accidentally, I had misplaced it, and actually my dad had taken it and didn't know where it was for a long time. And then I had to get a copy of my birth record, of my birth, and I didn't know back 40 years ago what was going on.
Two titles, and then inform the
ended up getting
file.
Certificate from the, huh?
Did you merge the two titles and inform the master file record keeper that's what you did?
No, CW.
And unless it's under trust, then I don't know.
In a court case, do we settle whether or not use a copy of the birth certificate to discharge a court case, or does that discharge the whole account?
Well, I think if you applied a certified copy of the birth certificate into the case, it would probably discharge the case.
But that's debtor creditor again.
Well, if you did it under trust, that's what I'm assuming, like we talked about under NEXE.
But isn't discharge a trust term? I mean, isn't discharge a debtor creditor term?
Yeah, discharge is a debtor creditor, yeah.
Christian?
Yeah.
You asked if I did anything with the public identity, with the birth certificate, right?
Right. Uh-huh.
Well, accidentally, all the documents that comported with that document were all stolen at one time when I was in another country by an ID, ID theft ring. And I had the police come in. I had a bunch of attorneys come in. It went to Supreme Court in that country, and I got documented as that identity was stolen, and all documents were null and void.
Yes.
Again, by accident.
Uh-huh.
And then I never used that identity ever again.
I don't know. What's the master file say?
I don't know. I went into U.S. Passport Agency a couple times. Showed them. They asked me for identity, who I was, and everything. I said I didn't have one. What my name is now. Showed them the Supreme Court documents, and they let me go through it. They let me slide.
Yeah, see, you showed them a public document that they recognized, and that was the whole effort.
I did.
And that's what we're trying to do, create public documents that they can recognize. Because if you've got documents they're accustomed to seeing, then there's your answer. It goes right through.
Well, it didn't go right through. They didn't want to do it, by the way, but they had to.
Yeah.
But then again, what kind of situation was those documents created out of? Trust.
So if we get copies of our birth certificates, then what? We claim them. We probably claim them in UCC1 and county as trust of this trust property.
Yeah, if you're going to use it as trust. Yeah.
And then use it to discharge.
Yeah, I always like the claiming first because the claiming gives me ownership, and now if I'm owner, I can do whatever I want with my trust res. I can now.
I like it.
And I can move it.
Hey, Christian, Eric.
Yeah, Eric, how you doing?
Great, thanks. Hey, I'm getting ready to create a couple trust sheet for a couple cases, and at the same time that I do the one, I can do the three, correct? When I send it over to the SOS, right?
Got a number out of the one to do the three.
Are you making a payment or are you making a termination on the trust?
Well, it's a court case, so I want to assign, I want to claim, and I want to move the title.
Okay, so next
trustee.
Probably do both of them simultaneously. Yeah, you could do it all in one.
Okay.
Form the trust all at once. Yeah.
Okay, and in Florida, we have FloridaUCC.com. Can I do those online, or do I need to send them snail mail?
That's the problem. UCC is that you got to send that stuff in, don't you? Here in Florida, that's the problem.
Okay, so yeah, you're familiar with that as well. That's what I thought.
Yeah. Why we do it?
All right.
Go to Kentucky.
Before you can do the three, you have to have a number on the one to modify. So how can you do them simultaneously because you don't know what the number is going to be?
Oh, that's a good point.
Otherwise, I'd like to know the answer to that one. It causes two actions.
Yeah.
Okay, so
claim it first.
So send in the go ahead, I'm sorry.
Yeah, claim it first, and then you could probably do it right after that. Do another one, and if you did it online, you could do it practically all in one. You do two separate ones, but then they're going to have two different timing sequences on them.
Is that a problem?
No, if you could prove. I mean, it'd be better if you did them one day and then 1 day apart, but that would be absolute proof. But if they got the timing sequences on them, if you made one at 11:57 and the other one at 12:03, you did the one first and the three right after that, two separate ones.
You're suggesting if we did it online?
Online, yeah.
Okay, well, I don't think we have that option here in Florida.
No, we don't. No, that's why I go to Kentucky or some other state and do an online filing.
Oh, okay. Well,
Kentucky has it.
What for it?
Kentucky filing
online.
$5.
Say, y'all talked over each other one at a time. What was that?
In Kentucky, the last time I filed, we filed for $5.
Is there a website you can lead us to? Because we'll all use that.
Just go to Secretary of State, Kentucky, and look up their UCC filing.
Okay. And even though we're here in Florida, we can still use it because it's not a matter of a state filing; it's a matter of it being public altogether, right?
Correct. Yeah.
Okay. And now, something everybody keeps talking about that I don't have a clear understanding of, because when I look at my birth certificate, it says birth certificate. It doesn't say certificate of live birth, and I have the original that was done at the hospital that I got over the years, and I'm just trying to figure out if that's the original that I know was done at the hospital. Where is this certificate of live birth?
That'd be someplace, and I think they're kind of reluctant to give you that one.
The state has it somewhere.
Did you go to the Census Bureau in the state?
No, I didn't. I just took the one that my parents gave to me because I just thought that was it.
Go to the county registrar where you were born, and then ask them. You know, maybe it's a health department or something like that.
They'll certainly give you one, but it's usually an inflated price. Here in the state of California, I ended up paying for certified copies of live birth. I paid $9 a piece. I ended up getting 10.
Well, what I have here is it says certificate of live birth, and this is a copy of the document that I got from the hospital. So if this is what I get from, for example, the people that produce the records from the state of New Jersey, is there a birth certificate?
Got to be a live birth record with the doctor's signature on it, and
that's what I'm looking at.
Mother as the informant.
Yeah, I'm looking at it. I'm looking at that right now.
And then there's the birth certificate, which is the bond papered one with all the numbers and looks like a bond.
And what this looks like a bond, and it has a copy of the certificate of live birth on it.
Oh, okay. So maybe they're dueling it, you know?
Say it again, Christian?
Maybe they're dueling.
Putting both of them together.
Yeah.
That's what they did on mine, too. They took on bond paper, they put all the brand new information, updated the old information of my live birth, and put that dead center, and then they certified it.
In that case, you got a merged title. All you got to do is record it as merged. Great.
You know, that's not a bad idea.
Outstanding.
So if it's merged, then I can go ahead and in order to get the dispersion.
Yeah, you just never created the records under trust that it was merged. But I would check and see whether or not you could just get that by itself without the bond paper thing.
Well, I have the original without the bond paper.
There you go.
Okay, you got the original without?
I do.
All right. Why don't you test a copy of it yourself? It's your document.
So make a copy of it and attest it.
You're still alive?
Say it again.
Is your mother still alive? Who signed it? Your mother signed it there.
No. Her and my father's names on it, but the doctor signed it, and
isn't your mother's signature on there someplace?
No.
How many signatures are on
it? 2. It says certifier's name. We got the doctor who's the certifier, and it says I certify the. And then I don't know who this other person is. Let me look at the other one. Maybe I can see it behind it a little better.
Christian?
Yeah.
When you're using the Secretary of State for the filing of the UCD, would it matter if the state goes bankrupt?
No, a lot of records are still public.
Talking about California, aren't you?
You know, Christian, I'm looking at this birth certificate again. You know, the certified part. And I think you're probably right. It says at the top, it's State of California Certificate of Vital Records, State of California Department of Health, and then it's on cotton, and then right dead smack in the middle it says Certificate of Live Birth. It's got all the pertinent information, including my mother's signature, and at the bottom it has one of those grocery store kind of bars that go across the bottom with an account number that is systematically from 1 through 10. I've got different accounts for each one of these birth certificates.
Mm-hmm. Okay, here's
something. And then it's signed and stamped by the person out of the deputy director.
Chris?
Yeah.
Those are not account numbers. Those are just sequential numbers for the amount of times that you've ordered one.
Oh,
like a serial number on a dollar bill.
well then it must be 28,847,303. I don't think I ordered that many.
No, the serial number is probably the last digit. You know, the sequential. If you said you ordered as many as you did, just look at the numbers and see if they're in an increasing order.
They are.
And that's that's the bond paper, serial number of the bond paper. You keep track of it.
Okay, so that represents your asset. So now flip that thing over and sign it without recourse and pay to in blank and sign it by trustee and your signature and forward the strawman account, social security number without the dashes, and go pay something with it.
Okay, will you put that endorsement on the back?
Yep.
So I can go ahead and pay off any debts, including the alleged debt that the mortgage company has on the house.
Yep, because that's in bearer form.
Well, I'm glad I ordered several copies too.
So review that EXE in your state.
Christian,
I didn't understand what that means. The NEX or the NXE. What is that?
NE, another word, EXEAT. NEXE.
Florida Statute 68.02, right, Christian?
Yes, yeah. Number 4. Surrender of the surety as payment and discharge for the obligation. This is for the undertaking.
So that's NE and then a break, EXE.
EAT.
You were cutting out. I'm sorry. Can you repeat it again?
EAT.
E.
That's on the end.
Yes, NE.
EX.
NE, another word, EXE. EXEAT. 2 words.
Okay. Got it. And what is that supposed to indicate?
That's discharge of the surety's obligation or undertaking upon presentation of the special deposit, which is a special bail.
Interesting. That's a new word for me.
Over this couple of shows ago.
Yeah, I missed a couple of them. I had to go and tell things.
So, Christian, going back to the birth certificate, or the certificate of live birth, it has my mother's name as the informant, but it doesn't have her signature. Does that sound like anything anybody's encountered before?
I don't know. Chris said
mine looks like that.
Chris said that his was like had his mom's signature on there. Mine does. My mom's signature's on mine.
Okay, so even though we might be holding a certificate of live birth, all of them that are the original might not have our mother's signature.
Apparently yours doesn't. So if that is a live birth one, then apparently that doesn't have to have the signature on it then. But does it say that she's the informant?
It does. It does, Christian.
Well, sounds like it. Maybe they were missing the signature. I don't know.
A separate application.
Could be.
Yeah, and the 2 signatures that are on here. One of them, it says, "I certify that the child was born in." Kind of hard to read. On the date stated above, and then below that it says certifier's name. So that was the doctor who signed it. That certified that the date that I was born, and then we got the registrar's signature. And those are the people who. So if my mom didn't sign it, then how did she actually do the grant? How did she actually be the grantor in this situation? Because doesn't she have to be grant res?
Slide.
Okay, so again, no party needs to know.
Can anyone hear?
Yes.
Yeah.
Hi, this is Nora. I have a California certificate of live birth, and then I sent for another one from online. Anyway, my birth certificate is missing the first 3 numbers, and anybody from California know what the state number is?
104.
104. And then the other one that I got didn't have any of them. They were all completely erased. But that can still be used something with, right?
What I had, they did the same trick with me one time, and what I did is I sent them all back, and I demanded to give me one that was valid.
Oh, right.
I told them they were giving me fraudulent documents, missing numbers.
Right. I was thinking of doing that, too. I still
didn't have any problems.
Oh, is that through Vera, whatever it is, that company?
No, I went direct to the health department.
Okay, maybe I'll just write them a letter. And we're in Minnesota right now, and they're saying they're refusing to give us a certificate of live birth that's certified. They'll just only give you like a copy that's not certified. So we're trying to write them letters and figure out who to go to. I don't think that's legal. They're telling everybody that.
Maybe try the census office in Washington, D.C.
Well, if it's on bond paper, that's really is a certificate.
No, they're not. They're sending you when you when you ask them in Minnesota for a certificate of live birth, they send you this fake thing that's bond paper, but it's just all capital letters, no information, no signatures from the mother, nothing, and it's called a birth certificate. And the certificate of live birth, they're saying, no, we won't give you a certified copy of that.
We'll tell them that's obstruction of justice.
Were you in the call earlier when we talked about the birth certificates, the two titles?
No, I got in late.
Okay, you missed it because there's two. There's the live birth certificate, the one the mother usually signs, and then there's the birth certificate, which is what they usually give you. Those
right.
two titles.
I know that.
The private side is the live birth. That's the private title. That's the asset title. And then you got the birth certificate, which is the public side. That's the debt title. When you merge the two together, that terminates the trust.
Oh.
And so the idea is to get your live birth certificate?
I was trying to get one for my friend here for his live birth certificate, but they keep sending us these horrible things with the all capital. It's a birth certificate, but they won't give anybody here a certificate that's of live birth that's certified. Only an uncertified copy. So it's an outrageous.
Mm-hmm. Wait a second, I'm lost.
Yes, because
you get a birth
corrections can't certify what the real man or woman did. It was a private side title. They can't certify that because it's still held in the private. They don't hold it in the public.
And can you get a copy of it?
Yeah, get a copy of
but
it.
not a certified.
They can't certify it. They can only certify documents that are in their public realm. That's not a public realm document. That's a private document.
Where is it?
Minnesota.
No, where's everybody else's? Where's the live birth certificate versus the state one that they give you a copy of?
County.
Well, that's
holding
what
it
I'm talking
in
about.
trust, not segregating it, because they're holding the private and the public. They're segregating it. They're doing exactly what they're supposed to be doing, keeping it in trust.
Christian?
Okay.
Christian?
Yeah.
This is Floyd. I'm looking at my certificate of vital record. It says copy certificate of birth. It has my mother's signature and my father's place of birth, and then it has the doctor as the witness or attendant, and it's a local registrar of Wisconsin and the state of Wisconsin. And it's a certified copy of the original birth certificate. So how does that work out?
It's like the difference between filing and recording. One's private, one's public.
But it sounds like they merged the titles on Floyd's birth certificate, doesn't it?
Yeah, on the one yours, it seems like they have combined the two of them.
I mean, just like mine, it sounds like.
Yeah.
Is that on bond paper, Floyd?
Pardon me?
Is that on bond paper, Floyd?
Yeah.
Yep. Yeah, same thing as mine.
Yeah. In fact, it's got a watermark on it.
Well, the one I have is not on bond paper. It's on a piece of paper, and it was, I don't know if you want to call it certified, but it has a seal on it.
Are you talking about your original, Christian?
Yes.
Yeah, I have my original that has a raised seal, and then I ordered additional copies. It has a raised seal, and now it's on bond paper.
Well, my old one doesn't. It didn't have bond paper. It was just a piece of paper, a photocopy. It was a photocopy reproduction, and then they sealed it.
Well, that has to go back to the county, because the original county is the private side, and the county of, which is delivering the bond papers, are the public side.
Yes, and that's where I got mine in the county health department.
Well, that's where I got mine too, but mine has both the county seal on it and the state seal.
Well, maybe go back and see if you can get the other one. Tell them I want the other one.
The live birth?
Yeah, I want the live birth one.
The live birth has to be registered to the local county. The local county has to order out the record of the live birth.
Yeah, they got it on a photostat copy back there someplace, so they can produce it for you. Just probably have to ask for it right.
Yeah, I was about to say they might redirect you back to the Department of Vital Statistics to say that's where you go for your birth certificate, so that might be the key is asking for it the right way.
This says this is the Bureau of Vital Statistics.
Right, I'm saying that's not the one you want.
Oh.
You got to learn how to ask for the proper one, the private one, in the county.
Well, if we take the birth certificate, that's the fictional one, and number 4 under NEXED is the surrender of the defendant by the sureties, where the surety of defendant has the right personally or by attorney at any time before the bond is forfeited to take the body of the principal, and the principal is the corpus or the res property in a trust, and surrender him or her in open court, or deliver, and delivery is a formation of a trust, deliver him or her to the executive officer of the court, now that's the sheriff, who shall detain the principal as in cases of the surrender of the principal, by special bail, that's special deposit. At the time of delivery to the officer, the surety shall take a receipt for the body and file it with the clerk, and that receipt is the birth certificate. If done before the bond is forfeited, the surrender or delivery discharges the surety from his or her undertaking payment.
Now, Christian, I was talking to Rhonda recently, and we were talking about meets and bounds and how it applies to more than just to real estate, about how it actually applies to us and how we haven't properly submitted a survey, so the public feels like they have domain over us because we failed to do that. I don't know if you've had a chance to talk to her about that, have you?
No, but really the trust is going to prevent the survey from getting a perfect title again.
So we don't need to worry about.
And then when you make the trust, you're actually merging the titles, and you're perfecting the title by merging them together. You got an legal title again.
So by having a trust receipt, we don't have to worry about the meets and bounds issue.
I don't think so. No, that'll bring the perfect title forward again, merging the titles.
So is the certificate of live birth? Did you call that one thing, the certificate of live birth?
The surety shall take a receipt. That's the birth certificate for the body and file it with the clerk.
Okay, so that's the certificate of live birth.
No, the birth certificate, the public side.
The bond paper.
Okay, because I just found mine, and one of them says
public
life
certificate, the public side birth certificate. Turn it over and endorse it, like we talked about, without recourse, and pay to in blank and trustee and a straw man account. Endorse it on the back. Surrender that as a receipt for the body. File it with the clerk, and that delivery discharges the surety from his or her undertaking or his obligation. Surety.
Okay,
surety goes.
How do you do that as a clerk if you hand it to the sheriff?
No. As the
you just have a copy.
It says, and surrender him or her in open court, or deliver him or her to the executive officer of the court. That's the sheriff. That's the principal.
Okay. But unfortunately, where I was born doesn't exist anymore.
Of course it doesn't.
Neverland.
I can't return it. I was born in the territory of Hawaii.
You can't get past go. You don't collect $200.
Well, I guess I would turn it over to the sovereign nation of Hawaii now.
Create a title or something.
Well, the one I have one that says a birth certificate, but it's from the territory of Hawaii and from a hospital. It says birth certificate, but it doesn't look like it. It's not signed by my parents.
Well, make a declaration, a political election, because nobody can do that except you, and just declare yourself wherever you want to be.
Well, don't worry, I'm about ready to do that.
Do a domicile.
Huh?
Do a domicile.
I don't want to do a domicile. I don't like that word.
It's not a resident.
I don't like resident or domicile.
Well, you live on the planet, don't you? That's a domicile.
What is it?
If you live on the planet, that is a domicile.
Oh, don't go presuming now.
Where am I? I'm domiciled in this body.
Huh?
Where am I domiciled at? I'm domiciled in this body.
There you go. That's closer to home.
That's probably okay.
Name of the dwelling.
In this flesh and blood vessel.
Yeah, this bag of portable dirt.
Portable dirt. So, Christian is just saying, take the certificate of live birth, endorse it on the back, and return it to the Department of Health of the state that you were born, is what you're saying.
No, I'm talking about walking into open court and giving a payment by the birth certificate after it's been endorsed, and that releases the surety.
But can they abuse that instrument and take as much money as they want?
The res. How much is it worth?
Well, that's right. There is value. No set value.
Well, if you do that, do you have to then go to the IRS and report that?
You might want to, just to report that they have to pay taxes on the amount that they were screwing you for. You serve a W-8 on their butt. That's what you do.
Christian?
Yeah.
The IRS is only one of 54 different tax trusts that they have us in. I guess the idea is that if you can get that Social Security trust, and that's the birth certificate trust transferred at 18 to the Social Security trust.
I think so, yeah.
Okay.
Spill over there.
Now there's all these other trusts that we don't even know about, like in your telephone bill. They've got the war debt of 812 in there that everybody pays. There's a ton of secret trusts that they have everybody paying in. So I guess the Social Security trust would be the master trust, and all those other trusts are all the sub trusts. And when you deal with the Social Security trust with the IMF, then it's all those sub trusts, no matter where you know they are or where you don't know they are, whether they show up on your individual master file report under under a FOIA request, that all those things you'll be removed from?
Yeah, after terminate the straw man account, yeah.
So then if AT&T sends you a bill for your telephone, and under there they have a 1% tax for the lower of 812, you have to identify that that's not owed by you?
Do I have to identify it's not owed by me? You mean under the new LLC or the old one? The old straw man account?
Well, I guess under the old strawman account, it is what it is. But under something new, you would have to know about all the sub trusts. Wouldn't you have to identify the sub trusts, at least as many as you know about?
Not really. If I give an order to pay the debt, all debts associated with this account, and I leave it blank, let them fill it out. What do I got to worry about what the amount is?
But, I mean, would you also order them, to send you a receipt for the payment for all the things that they paid?
Yeah, you ought to order a receipt out. You could, yeah.
You have to have proof of payment.
The proof of payment is my instrument I gave them.
No, I mean proof of them doing what you asked them to do.
You don't ask them, you order them.
Yes, you order them.
You ordered them, directed them, commanded them. After you've done that, don't you put them through and make them give you documentation that they did what you directed them to do?
No, here's the thing, it's reversed. You know, in the public realm, they give you a receipt. On the private side, you give them a receipt. You make up the certificate of deposit of the special trust, and you give it to them. It's like what
right.
I said
So
earlier.
you give them but if it's gonna pay off 50 sub trusts, don't we want a record of the 50 sub trusts that they paid off with that deposit, that special deposit?
They're just debt titles.
Yeah, don't we want a record of all the debt titles were relieved of?
Well, I'm terminating the trust. That's going to be proof that it's done.
And we create the receipt. We don't wait for them to.
No, everything they pay.
And we're not paying anything. We're merging titles. Payment is on debt, the public debt side. We're merging titles on trust.
Okay.
And our receipt.
I mean, you said, we don't know how many actual titles you've got in there.
No, I don't. Nor does it matter to me anyway. I'm taking the master title of the asset and telling them, hey, whatever's the opposite of that, touching that, merge the two together and zero it out. Terminate this whole account. There's nothing associated with it once it's terminated. It's gone. And the only way you can terminate it is pay all.
You don't want proof from them that they did it?
The proof is that it's terminated.
Yeah,
Jacob, you created the proof.
No. But how do I know that they followed directions?
Because you told them to.
That's not good enough for me.
As king.
Huh?
As king, you told them to.
Yeah, but I want them to show me proof.
Well, okay, ask for it. You know, if they give it to you, great. If not, well, I'm going to go on.
I mean, you're supposed to have a proof of 2 witnesses minimum.
Yes,
create
well, it's up to you to create the record for the proof. They're only like the DIB hearing. I bring the records into the DIB hearing. I provide the evidence or the records that I did such and such an act or deed.
See, if we wait for them to give it to us, they're never going to give it to us. And neither do they have the power to do that. The only way they could give it to us, Jacob, is if we tell them.
Well, it's like a FOIA request. In order to get something from them, you have to be sick and ask exactly for it.
Well, I have a trust receipt, which is a record of a payment, as I issued a asset title against all debt titles.
Okay, and then you bring those records into the DIB hearing.
Yes, I'm issuing a certificate of deposit for my special deposit.
Has anybody ever known anybody who's been in the DIB hearing?
Yeah, I've heard some people that have been. Yeah.
I missed it. What's a DIP hearing?
Didn't you say that what do you call them? I can't.
Data Integrity Board. Data Integrity Board.
No. Public. The guy that does your signing for you in public. I can't think of it.
Notary.
Notary. Yeah, thank you. Notary public. Didn't you say that could be a DIB hearing?
Yeah,
at one time.
Even an attorney trying to collect a bill should be a DIB hearing, because if he decides not to collect from you, he just did a judgment. It doesn't have to be a court case, although it can be. It doesn't have to be in the although it can be.
Christian, in Kentucky, can we do the online filings for $5? Is that what you meant when you were talking about that?
Yes, last time I filed it was $5.
But you could do it online is my question.
Yes,
Okay. And, pardon me. And one of the things that I'm trying to figure out from the source of when they can utilize our signature by accommodation, where does that actually begin when we actually give them power of attorney so they can utilize our signature by accommodation? Do you have any idea where we might be able to look back through history and figure that out?
The first thing that we signed in the whole series or whatever it is, that in the case of the mortgage, would be the application.
And maybe with the IRS way back when we took our first job and signed a W-4?
Yeah. Filed a 1040, signed that.
And recently you mentioned something about a green passport that gives you orders of do not detain. Did you have an opportunity to learn anything more about that since you brought that up?
No, I haven't.
Talked about? And if anybody on the call knows anything about that, where we might be able to get our hands on one of those, please speak up.
Repeat the request.
It's the green passport, the green U.S. passport that is set up for is that American nationals? Would that be the proper terminology, Christian?
I'm not sure if that's what it was, but yeah, could be.
Green passports are you can get those through the Secretary of State, but you have to go in as a I think it's one two something like that. It's a particular requisite that you have to qualify in order to get one. But you can get those right through the SOS out of Washington.
Yeah,
okay.
World, whatever it's called, passport.
Well, you can get one from United Nations Turtle Island, which is going to be the most sound because the United States of America, under Executive Order 13175, has acknowledged the United Nations of Turtle Island as a sovereign nation unto itself. Therefore, it is authorized to put out its own passports and its own visas, of which are almost nearly finished, where people travel just about anywhere in the world. World Passport does not have visas. They only can issue a non-commercial, non-United States government issue passport, of which is better than nothing.
But Chris, I guess my concern really with that is for that United Nations Turtle Islands passport. Do you know if that's going to have that designation of do not detain attached to it?
I'm getting tired, so I'm getting ready to shove off here. So if you guys want to talk a little while.
Actually, can I ask Christian one thing before he bugs off?
Okay, go ahead.
Yeah, just about, I sent you a few emails on getting invited to the ambassador call, because it seems like it's hard for me to get in if I try to do it through somebody else. May I just send you another email? Will you keep an eye out for it, Christian?
I was going to get a hold of you and JC as soon as I made the number reservation for the number.
Okay, so do you want to do that by email, or what are you suggesting?
Yeah, did you get a hold of JC? Did he tell you, give me your number so I can call you?
No, I didn't know about that, but I'll get a hold of JC and get that to him so you can reach me.
Yep. Okay.
All right. And one other thing, maybe I don't know if you want to talk about it now, but recently I read some information about a warranty deed as a mortgage. Basically, the county is utilizing that as a mortgage to draw taxes from us.
Yeah, I think Chris was saying something about that.
No, that was somebody else.
I think. Let me think about it. I think it was Candy, who, if I'm right, is on the Trust on Topic group as Typhoon, I think, if I'm right about that. And it was a pretty interesting read. I don't have a lot of information on it. If nobody's familiar with it, I'll read it and I'll bring it up for another call. But it's a pretty interesting premise because, again, they're drawing a payment out of us every year, and it would make sense as far as the structure as to how they're doing that, if they're doing it through the method of mortgage and then through the foreclosure, because they certainly foreclose on us in order to take the property from us, just the way a bank does, right?
We were looking through the statutes, and we were finding out that they're also drawing them off of the driver's license also.
Mortgages?
No, they're drawing funds off of the driver's license, creating just like they're doing off the
Yeah, I can confirm that because I filed a lawsuit against the state of California. Every one of these people, right through the Comptroller and Treasury, have securitized your driver's license, your signature, and your vehicle registration. Each and every one of these are sitting on the municipal's market, securities market, and the derivatives, I traced it all the way back to find out that the derivatives of payment and at the end product, when it's closed out after 3 years of where it has to be reapplied for, goes to the federal, state, county, municipals, employees union, of which all public offices are part of. So it's a closed union shop. It's racketeering at its maximum.
So they are drawing funds through our not only our property taxes, but also in securitizing our driver's license and our sidewalks and everything else.
Yeah, probably more.
They take your streets, they have commercialized the streets, and whoever was the construction outfit under that institution and that license, they are still securitizing, even if the tracking housing was done 50 to 100 years ago. They have securitized and are maxing every street, every address, and everything. They've prostituted everything they possibly can.
Yeah, I'm aware of that. Okay.
And another fact about the mutual funds market and the municipal market is neither one of them are taxable. They're all tax exempt, so they don't have to report any of those to the IRS. Go figure. In the state of California, the Superior Court of California is exempt from having to report income.
What was its source?
Huh?
What was its source? The reason why they don't have to report it is because their source was foreign, is drawn off of us, private.
Right.
Therefore, they don't have to do an IRS tax. They don't have to report it.
Yeah, and if you go to the IRS and look for foreign agent exemption tax form, they have one right there that they fill out and they send that in, that they're exempt from having to report or pay taxes on any of this stuff.
So now we duplicate that with the LLC we form on the public side, and we exempt it out basically because it's not effectively connected with a business or trade. It's private. Its source is private. It's drawn off the private source real man assets.
And out here in the state of California, the Superior Court of California has an EIN number that has been issued to it that's giving them the ability to be on Dun & Bradstreet. While the same is true for the Bar Association for the state of California, it has its own EIN number. Well, guess what? When I did a fidelity lookup check on both of those separate EIN numbers, both of those EIN numbers and organizations go to one offshore account.
Puerto Rico?
Not Rico?
Puerto Rico?
No. I thought you said, do you want to do a Rico?
Oh, Puerto Rico.
I don't know where it went. I've got it printed out somewhere. I build folders, so in one of my folders, I actually printed that stuff out. So what we're also finding out here in the state of California is that they are not maintaining a constitutionally based insurance, a public hazard bond to protect the public. Now, they've been pocketing this money, the federal funding that's coming out of the federal government that is to supply them with the money to properly bond themselves to protect the public. They're putting these federal funding into offshore accounts. They're raping and pillaging as much wealth as they possibly can out of California.
You and Phyllis dug that up, didn't you, Chris?
Huh?
You and Phyllis dug that up, didn't you?
Well, we've been working back and forth. She's got her own agenda, and we kind of merged our information together to come up with bigger. But most of my stuff I just shared is all my own hard work.
Oh, okay. Now, would it do us any good to do the tracking on the QSIP information, for example, on our tickets or our case numbers in court for when we go in camera, and express the trail of the money for when we assign the res to the trustee to say tell them we know your game, we know exactly where the res has gone. Do you think that would give us a better ability to affect remedy, Christian?
No, not really. Although you could, but I don't see how it's going to make any more difference.
Yeah, I agree with that. I think that if you're going to use that kind of information, what you need to do is work under the Whistleblowers Act and report that they are tax evaders and that they are in these offices without proper public hazard bonds, and they do not have fleet codes. So therefore, they are rogue. They're working our government with insurrection and treason. These people are embezzling public funds, and they have breached the public trust.
Yeah, but
that's what we're finding out about California.
That's on the private side, though. Really, they don't need them on the public side. They don't need they got a colorable office, which what we're talking about, where everybody's talking about is they got to have a bond, they got to have an oath of office. That was under the Republic. The Republic's held trust. So now they don't need it anymore. That's why they're doing it right before our eyes, and we keep on saying, hey, but really it comes down to they don't have to have it. We're not.
That's right. They're corporations.
Yeah.
Yeah, if you go back to Rod Klass's conclusions last year when we did the Quorum Non Judice and those sets of documents, it was legislation that had passed all public offices right down to the garbage man over to the United Nations and put us under international law, of which gives every public office that is elected the opportunity to swear out of U.S. citizenry into international law. So you're right. They do not have to do anything that is on the Republic form of government.
If you want that stuff back, you've got to merge the title, bring the Republic back. Terminate the trust.
Right. That's why we have to do that. Exactly.
Now we can get the Republic back, we can get our common law back, we can get everything that's being held in trust in the private, get it back. Eric?
I got it.
Eric, wait a minute. Eric, well, we were talking before about, I forget what's Monday's call, and there was it was between JC and you, and we were talking about the protective order.
Yeah.
You were saying the protective order had to be, and JC was saying, well, I don't think you have to have it all the time. Remember?
I remember.
I did some further research on that. I think it really has to be an express protective order act, and because that's going to set up the CCI. If you don't, then it's not going to be classified as CCI information. So I think you're right.
So just plan on putting it together and doing the motion and doing the protective order, because otherwise they're just going to look for every opportunity to roll over top of you.
If you don't do something going in that sets up that you got CCI from the beginning, it could be construed that you attempted to not make it private because you have no act or deed to say that it is. And that act or deed would be the protective order. That's an actual action that you take that sets up CCI or trade secret information. And that shows that you intended it because you did an act that maintained its privacy.
Now, what about in a case that's already been adjudicated? As long as you create the trust receipt and then do an NOI from that point, you can always go ahead and do the protective order at that point, right?
Yeah, it's already been adjudicated, yeah.
Okay, just trying to make sure that it's never too late to go back and do it based on your premise. Now, I have an interesting situation. I recently got a speeding ticket and I did a refusal for cause. And I got from the JA a signed order that the judge refused my request for a refusal for cause. And I have the judge's signature on it, so I'm looking at this thinking, this is red. She gave it to me.
I thought Christian said that refusal for cause is exactly that. It's a request.
No, my point about this is that because I did this action and now I got something back, I got an order from the judge with the judge's signature on it, I'm looking at this thinking, this is res in this case. Not only do they have mine, but I have theirs because she sent it to me. She transferred her res.
I see what you mean.
And it's not an original, it's a copy, but still, it's a copy of her res that they sent through the U.S. Postal Service that I have a canceled envelope with, so it has been transferred.
A certified copy?
No, not a certified copy, but I don't think she's going to deny sending me this order because she denied my refusal for cause. So she's not going to deny that it was sent to me. So
Was that metered mail?
I don't know that much about mail. How do I determine it's metered?
One of those that they generated out of a machine?
Yeah.
Okay, that's mail fraud, and that is a violation of UPU that bypasses the payment to the postal union, and therefore it's not just mail fraud, but it's I think it's embezzlement of UPU standards.
I've heard of that, but has anybody ever exercised that on this planet?
Well, we're getting close. Believe me, I've got some other stuff going on.
On top of that, a copy of the signature is never going to stand in court.
But let's set the mail fraud idea aside and just utilizing the judge's signature that she transferred to me as res.
It's a copy of the signature. It won't stand in court.
Yeah.
That should be the original.
All right, well, I'm going to go, guys.
Thanks so much, Christian.
Question on that. If that's the case, would you then want to do the UCC-1 claim that as trust res? And if you do that, can you just do it by computer, or should you have a witness, such as a notary, do the UCC-1?
Is that directed towards me?
I guess Christian gave it up. I guess it's
Yeah,
not paying.
but I'll leave the Skype window open. As soon as he sends that stuff to me, I'll relay that stuff out to everybody.
Okay, all right. So look for it in about a half hour or so.
That's fine.
Okay. Night all.
Good night.
Thanks, Christian.
All right.
Night.